Okay, Baltimore City Council Legislative Investigations Committee. We're here for legislative oversight, LO 23-0031, Baltimore City's analysis on the sale or control of the conduit system for the purpose of discussing the deal with Baltimore Gas and Electric regarding the city's conduit system and to obtain information from the executive administration about the city's plan for the maintenance, capital improvements, or any other terms of the duties under the franchise agreements related to the underground conduit system. I'm Eric Costello, councilman from the 11th District, chair of the committee. I'm joined to my left by City Council President Nick Mosby, Councilman Isaac Yitzi Schleifer, 5th District, member of the committee, Councilwoman Odette Ramos, 14th District, Councilman Chris Burnett, 8th District, Councilwoman Felicia Porter, 10th District, Councilman Mark Conway, 4th District. To my right, Councilman John Bullock, 9th District, Council Vice President Sharon Green Middleton, 6th District, member of the committee, Councilwoman Danny McCray, 2nd District, member of the committee, Councilman Robert Stokes, 12th District, member of the committee. To my immediate right is Marguerite Curran, staff to the committee. We have representatives here today on behalf of Mayor Brandon Scott and, of course, from the Office of City Council President Nick Mosby. I'm going to quickly run through the agenda before we get started. Couple ground rules first. When you are testifying, please be sure to speak into the microphone. The reason for that is this hearing is being streamed online, so the folks that are home that are not present in chambers will not be able to hear you. If you are not speaking into the microphone or you are too far from the microphone, you should be about this far away, I will politely interrupt you and remind you to please speak clearly into the microphone. If you do it again, I will again politely remind you, so on and so forth. We're going to do a little bit of a different format this evening. And in a minute, I'm going to turn it over to the council president to get things started in terms of an opening statement. But what we're going to do is we're going to start off with public testimony this evening. Members of the public who are testifying will be given 2 minutes to provide testimony. There's a sign-up sheet outside, which I've asked everyone who's testifying to sign into. I will start calling names off of that list. I will ask you to come up to the lectern right here and provide your testimony. Your testimony should be provided directly to the city council, not to the mayor's office, the agencies, the conduit users, BGE, or anyone else. It should come straight to the city council. We will then go through everyone. As you get close to that 2 minutes, I will remind you that your time is winding down and to please work on summarizing or concluding your statements. Once we get done with public testimony, please note that there will be a period at the very end of the hearing for additional public testimony for those members of the public who may come in during the middle of the hearing. So everyone who is here this evening will get an opportunity to testify for up to 2 minutes. After we get done with public testimony, we will then move to the panel of conduit users. We have representatives from 4 of our conduit users, BGE, Comcast, Quantum, and Crown Castle. They will be each given up to 5 minutes to testify. Once they have completed their testimony, I will turn it over to Acting Solicitor Ebony Thompson on behalf of the administration to provide any testimony that she wishes to provide. Once she has concluded, and any other members of the administration who the Acting Solicitor designates to provide testimony, we will then go to questions from members of the council. Colleagues, I'm asking that we adhere to our standard 2-question rule this evening. And then finally, at the end, for any members of the public who wish to testify who did not get an opportunity to provide testimony at the beginning, will be given that opportunity. And finally, at the end, before we recess, we will lay out next steps in terms of the committee's investigative work. Before we move forward, are there any questions related to the agenda as I've just laid it out? Just related to the agenda. Are there any questions? Okay, so I can assume that everyone is good with the agenda that we've laid out this evening. Yeah, we're not going to be and finally, we're not going to be taking virtual testimony this evening. Okay. Before we get into that agenda, I am going to turn it over to the council president to kick things off. Mr. President.
Thank you, Mr. Chair, and thank you for everyone who came out in attendance tonight, as well as those of you who are at home or at work watching remotely. Obviously, the council has taken some unprecedented actions in forming the Legislative Investigative Committee. I think that the work of this committee to date has been sound, has been proven, and is critically important for a couple common goals. One, to ensure that we have the best outcomes for this process for the citizens of the city of Baltimore. And two, to ensure that the council in its duties to provide oversight of the administration, that we do that in accordance with that. I think it's really important to understand and know the background, the history of how we got here. This has been a council that's attempted to work with the administration to better understand why we're here and why the structured agreement was established the way that was established. And unfortunately, we were not provided with the appropriate level of information or transparency or any sense of partnership and accountability. So that's why we're here. I would like to thank the folks in the administration for participating, particularly as it relates to kind of the leader of all of this in the solicitor, in Ms. Ebony Thompson, and as well as all of the citizens who've been reaching out via email, via social media, and who've come tonight in attendance. I would like to also thank the other partners, including BGE and all the other companies who are here in attendance tonight. Again, the goal is to ensure that we get to the bottom of this. The goal of this council is to ensure that we help produce the best outcome for the citizens of Baltimore, not just today, but for generations to come. And lastly, the goal is to ensure that this council is doing the work of the people by providing the appropriate level of oversight of the administration and of important actions and agreements such as this. So thank you, Mr. Chair, and thank you to colleagues for joining and participating.
Thank you, Mr. President. I want to also acknowledge former Mayor Bernard C. Jack Young, who's joined us today. Thank you, Mr. Mayor. With that, I will go in the order that individuals have signed up. We will start with Trenton Presoff. Trenton Presoff. Okay. Next is Rod Easter.
Good evening, Mr. Chairman and members of the council. Long time no see. It's been a while. But I thought it was important for me to come down and speak today. My name is Rod Easter. I am a Baltimore City resident. I'm a 43-year member of the IBEW, International Brotherhood of Electrical Workers, and I'm a small minority business owner. I lived in Baltimore City all my life. I've seen a lot of this back and forth on the TV about the conduit system. And what I want to talk about is the change in Baltimore Gas and Electric. In 43 years as an electrician and a minority in this city, Baltimore Gas and Electric very seldom years ago used local contractors and minority contractors. In the last 10, 12 years, that culture has changed. And I think about when Exelon moved its headquarters here, parent company of Baltimore Gas and Electric, the minority firms that were primes and subs on that project, Commercial Construction, Mahogany, AC Power, Horton Mechanical, minority contractors that didn't get a shot with BG&E before this time. So now I look at this conduit system that's coming out, that's the controversy, and I look at the opportunities for local minority contractors, both union and non-union, to be able to work on the system. I think that it's an opportunity for Baltimoreans to get to work. I'm done?
Just please finish, but yeah.
Okay. Well, I think I made my point. I'm for it. Thank you.
Thank you, Mr. Easter. Next up, Kobe Little.
Good afternoon, Mr. Chairman, Mr. President, members of the committee, and members of the council. I'm Kobe Little, and I'm here representing the Baltimore branch of the NAACP. Today, we want to focus our testimony on some rather disturbing allegations that we have become aware of. We held a press conference today with attorney Tanya Banya and several of her clients who have alleged that they have been victims of racially hostile workplace, perhaps cover-up, perhaps retaliation, and a system and pattern of exclusion from industry by BGE. And for us, the most important thing, the most important question that rises is, how does the city make multi-million-dollar contracts with corporations that have unresolved race issues at the corporation? As I've said earlier, we live in a city that has been subjected to structural racism and to inequality for hundreds of years. If we're going to move forward into a new era of equity, we need the city to be pressing anyone that it does contracts with to make investments in advancing equity, separate and apart from whatever the obligations of the contract are. So what I'm asking today from this committee is to examine how the city makes contracts without determining whether or not the people that they're making, or the corporations that they're making the contracts with, are in fact upholding the values of diversity and equity that are important to a thriving city. To that extent, what we think is necessary is that any contract that the city signs, any contract that the city negotiates, before the negotiations are complete, there must be a diversity and equity assessment. And as a result of that assessment of the corporations or the parties to the contract, a note attached to the contract negotiations that ensure that if there are existing issues, that those issues are remediated, and that a plan is put in place to prevent the recurrence of that type of racial hostility. So we would like to see that happen. We would like to make clear to the city that we think it's not a good look to support white supremacy through contracting. And the only way that you can guarantee that you don't do that is if you first do an assessment and make sure that the parties to the contract don't have a pattern and practice of white supremacy. Thank you.
Thank you, sir. Tanya Bana.
Good evening. Tanya Banya, it rhymes. I represent Ateem Lee and Malik Smith, as well as myself. All of us are residents of Baltimore City, and we oppose the City of Baltimore conduit agreement with BGE. I've been practicing law for 20 years. For most of that time, I've been practicing employment law. I also was duped by BGE's diversity and inclusion rhetoric. I thought that BGE was genuinely committed to fostering an inclusive culture. I thought that BGE was sincerely committed to supporting the communities it serves. I thought that the company's first African-American CEO, Calvin Butler, was a real champion of diversity. He has a lot of black faces in all the right places. But in the last few years, what I have come to realize is that BGE is the last company that the city council or the mayor should blindly trust to make a good faith effort to equitably use minority contractors. BGE has a company-wide and systemic pattern and practice of discriminating against Black utility workers and retaliating against utility workers who complain about discrimination. BGE also has a policy that prohibits employees who have been fired from working on Exelon's systems, property, or projects for at least 5 years, which indefinitely locks out of the industry employees, many of whom are Black and many of whom are residents of Baltimore City. BGE is the last company that you should be accepting at face value bald and unsupported representations about what they're going to do with respect to diversity. They are not honest. They are currently engaged in an ongoing cover-up of their discriminatory practices because they've done such a great job of rebranding the company as a diversity leader, when in fact they have a 200-year history of white supremacy and anti-Black culture. This is the truth. This is an open secret at BGE. And I know this because in investigating my client's claims, no fewer than 60 people voluntarily spoke to me, ex and current BGE employees, many of whom are white colleagues and former coworkers who are substantiating their former colleagues' claims of race discrimination. For me to be able to do that without subpoena power, for me to be able to do that without discovery is unprecedented. 60 people, many of whom have been locked out of the industry, who cannot get jobs in their chosen field and what they've been trained in because of BGE's policies, and they know this.
Ma'am, if you could please wrap up.
I'm not talking about microaggressions. I'm talking about nooses. I'm talking about a CEO who sent a picture, whose chief of staff was sent a picture of a noose and did nothing. And they will pretend and they will tell you that this is misleading and thus an anomaly, but there was a noose incident at BGE 6 months ago. So this is an ongoing issue. The city of Baltimore should not trust what BGE says. They should not take it at face value. And they should not be exempted from the discrimination, the diversity provisions of the city code.
Thank you. Mr. Kevin Brown. Oh, got it. Carmen Rajamani. Oh, got it. Christina Flowers. Yep, I already got that one.
Good evening, all council, community. You know, I want to take this opportunity to represent our underserved population more than anything, but I also want to represent our leaders and council. Really thanking you guys for putting this together, because when we're talking about the lack of transparency and accountability and the lack of respect that this mayor's administration not only give to you guys, but give to us as community leaders and advocates and stakeholders in this city, I really truly believe that this should be an effort where you guys really push and show us as the community of Baltimore City what you guys are doing, that you stand for integrity of every contract that goes through this city. You know, I seek righteousness. I seek the opportunity for us all to have a chance to serve in a good way our constituents of Baltimore City. So I thank you guys for putting this together, and I really am heartbroken when I see the pattern of this lack of transparency to this council, you know, that represents us as the constituents. We need to be more aggressive about the way that you guys are handled as well, because it should be with dignity and respect in the things that you bring to the community. We just need to boost it up and hold those accountable that should recognize and respect that we are the stakeholders in this city. Thank you very much.
Thank you. Michael Scott.
Chairman, President, Michael Scott, Equity Matters. I just want to pick up on what Attorney Banya and Reverend Little said, which is, you know, is the old church idiom. Everybody talking about heaven ain't going there. And everybody talking about equity ain't doing it. There's a lot of fakeity out here. The way we can be sure and have accountability and transparency is disaggregation of data. We need better data about what's happening in minority contracts. It needs to be disaggregated more wholly. There's a lot of incidents where we do not have it at the state level, we do not have it at the county, but there's no excuse with a city like Baltimore that's leading the way with equity to not be doing that, right? The other piece is our minority contractors, we are not hitting the high mark. We did a deal 20 years ago in New York City with a 25% set aside on a $4 billion transaction. We haven't even shot for that here. That's 25 years later, right? So I think we can do a better job of reimagining how we're participating, whether it's EBDI, whether it's Cherry Hill and the SB7. But you can't get to any of the big deals, the small deals, the things that fly under the radar through lack of transparency without the data, right? Because what these issues that have been raised cannot be benchmarked against what's happening day in, day out in city as it relates to the government dollars that are flowing, right? So you're gonna have to do a better job in order to hold folks accountable, of setting a high watermark for what the data actually is in these cases. And this will play its way out in court, but there's no excuse to rush something through. My understanding is that 9.6% is what BG&E earns on CapEx. So for capital expenditures, there's a 9.6% incentive. And so I need to understand what that means, right? I'm not a Wall Street analyst today, but there are plenty of folks who can analyze that and have a more clear understanding of what the actual impact is. We're in a state where the governor has said we're going to, and I'll wrap up, Ms. Costello, where we're going to not make it a suggestion but a requirement. We're at a day and age where affirmative action may be done away with the Supreme Court. If this city and the state are going to lead, we need to be clear about what we're doing. Thank you.
Thank you. Shariel Seltzer.
I'm Shael Seltzer, live in Liberty Square neighborhood. So in terms of the 7 million's been debunked, but this is what the federal government does. It actually costs more than a penny to make a penny, but they make it up with the dollar. Who owns the electric conduit? Baltimore is unceded, which means that any Native person can go to the federal government and claim this territory as their own with proof. The definition of a franchise may refer to a right granted by the government to operate as a legal business entity or provide some service of public nature in a certain graphic region. Definition of a sale is an item available for purchase and exchange at a reduced price for sale, on sale. This agreement is clearly a franchise. There is a tremendous amount of language in there which would make the city completely responsible for any accidents. BG&E is the worst steward. In 2020, on August 10th, 2 people died and 7 people were injured from a gas explosion, ruined people's lives, their homes just completely destroyed. BG&E still does not take any responsibility. BG&E and Exelon Company. Exelon, that building is not the headquarters. The headquarters is on Dearborn in Chicago, Illinois. Just to clarify, what does privatizing power do? In Illinois, they have surcharges and fees, and they bail out, and they give Exelon billions and billions of dollars, and this is in Ohio and New York, in New Jersey, all for the nuclear plants. And we're going to close them, we got to close them, we can't get enough out of them, we're going to close them. They scare people, they traumatize people, and
Ma'am, I'm going to ask you to wrap up, please.
God. much. This year, BG&E and Exelon Company is raising our rates twice. Once we just had in January, and the next one is in June. Just about every year since they've owned it, they've had tremendous amounts of hikes. This is very important. This is a PVC pipe. This is what they use to put the electric in, that they so nicely said how horrible this terracotta and such. This leaches polyfluorinated substances, it's PFAS. They leach through the cement that's put around them, and they go into our water and our soil, and they cause cancer. It could also be that they use polycyclic aromatic hydrocarbons for sealants. There's no laws regarding these substances.
Ma'am, I'm going to have to ask you to wrap up.
Okay. What we can have is streetcars that, like Kansas City, who have made billions and billions of dollars, even just from one streetcar, that 2.2 miles, because of the power of brick and mortar and developers wanting fixed transportation. And I want to work with you all. I want to move off public assistance. And Council President Mosby, I'm still waiting for an appointment from April 26th. Thank you.
Thank you. Okay, that concludes public testimony. Now we will move to the conduit users. Let's start with Quantum. You can use the microphone those are turned on? Okay.
All right, can you?
Yep. You can take your mask off when you're testifying, and please pull the microphone up and keep it, 5-6 inches from your mouth.
This good?
Perfect.
All right. All right, thank you for inviting us here today. My name is Kevin Brown. I'm the CEO of Quantum Internet and Telephone, and I am here to represent, with a few colleagues, some of the communications conduit users here in Baltimore City. My company has been around for 27 years. We're a local family-owned small business, and we are one of the smallest users of the Baltimore City conduit system. The conduit users currently lack sufficient information to support or oppose the BG&E proposal. If it results in improvements in conduit repair, expansion, maintenance, then it could be a good thing for all of us conduit users, the city and the public. The rights and interests of other conduit users must be protected, specifically reasonable notice of conduit activities that might pose a risk of damage. We need a process to resolve damage claims and not just have to sue BG&E. Ensuring that conduit work equitably benefits all conduit users and not just one user. We need to ensure that the eligible expenditures are in fact on conduit and not one company's physical plant, meaning BG&E's electric cables. At the mayor's urging, a BG&E representative met with the conduit user group yesterday for preliminary discussions over some of these concerns.
Please repeat that.
I said, at the mayor's urging, a BG&E representative with the conduit user met with us yesterday, and we had some preliminary discussions over some of these concerns. The BG&E representative was basically in listening mode, so I mean, we talked, he listened. But he promised to review the issues with others at the company. And we're hoping that we're going to continue to have some productive conversations with BG&E. The city has a duty to ensure that the conduit is well maintained and available to all interested users on a fair and non-discriminatory basis. It is unclear how the city and BG&E derive the total commitments for capital improvements and maintenance under this agreement. We did receive earlier today from the administration the existing conduit improvement plan, but we have not seen the conduit improvement plan with the added funds that BG&E is promising as part of their capital investment. The the city's current per foot charge for the conduit is right around $2.30, and it exceeds what the FCC has said is a proper rate when similar conduit is owned by a private party. The excessive conduit rates, they're a disincentive to broadband deployment and additional investment in bringing services to city and the residents and businesses of Baltimore. You know, one of the things I wanted to mention here is working in the conduit system is kind of extra difficult for us smaller providers. We don't quite have the resources that some of the other big guys have. And the high conduit rental rate really is a disincentive. A number of years ago, we had a project to build fiber from right around the monument up to the North Avenue area. We were building to a couple buildings that were being redeveloped for nonprofits and other services. And the city had raised its rates from 95 cents, which was what it was when we first started the project, up to the current rates of $2.30. And we had to abandon that project. It would have been good for the North Avenue area, but it just added too much cost, and we weren't able to make the financials work. We encounter a lot of difficulties building in the conduit system. A lot of times we encounter collapsed ducts, and we have to go far out of the way in order to get to where we need to go, and that just continues to add costs. We really would like to, continue to work in Baltimore, but that experience had really kind of turned us off from, working in the conduit system at all. We haven't done any projects, since then. I think, our experience is what a lot of the other conduit users experience. And, like I said, we would like to work with the city. I think there's a lot of things that can be done with the conduit system to try to close the digital divide. We've been doing a lot to work on closing the rural digital divide. Our company was recently awarded almost $15 million in state and local grant funds to essentially fix the broadband out in Carroll County. And we'd love to do that the same in the city, but the conduit costs just are too excessive. So we really need a good conduit system that is reasonable cost and doesn't have as many of the problems that I had described. I guess finally I wanted to kind of clear up some media reports of the BG&E agreement because it indicates that there's some confusion in the public about the conduit system. The conduit system is a series of empty pipes or tubes installed underground. It's really nothing more than that. It's not the wires, it's not fiber optic cables that runs through the conduit. The conduit system itself does not enable the city or really anybody else to provide broadband service. And a party must still install fiber optic cable through the conduit to provide broadband. And the conduit system is not comparable to a city-owned water system or gas system, which is really only used by one party to deliver one product. And that's it for me.
Thank you. Turn to Comcast next. Oh, Crown Castle.
Good evening. My name is Carmen Rajamani, and I am the Vice President of Government Affairs for Crown Castle. Thank you again for the invitation to speak with you all this evening. Crown Castle owns and operates the nation's most comprehensive portfolio of communications infrastructure, including towers, fiber, and small cells. That we have a national portfolio of fiber installations. We've been doing this for 25 years, and we have been operating for that time in Baltimore. We provide fiber to the city's schools, to nonprofits, to businesses, and to medical centers. And in providing these services to this vibrant community, we pay the city millions of dollars a year in conduit fees. Additionally, we do hire minority-owned businesses to help build our networks. And we pay them millions of dollars a year in construction fees. In 2022 alone, 93% of the construction dollars that we spent were allocated to minority and women-owned businesses here in Baltimore. The fiber we install also helps support our communications networks, which provide wireless coverage to more than 50% of the city's residents. As was underscored in the pandemic, wireless access is critical for digital equity. As Kevin has discussed, we do not have sufficient information to understand how the city BGE agreement impacts our business and our customers, but also your residents. To continue to provide connectivity to Baltimore, we have two operational concerns around capital improvement projects going forward. The first is the oversight and control of those capital improvement projects. That, as we understand it, under the agreement, BG&E has sole discretion on which capital improvement projects go forward. And then second, the scope and nature of those capital improvement projects. That, again, BG&E has exclusive right to prioritize their projects for their customers over other conduit users. Our third concern we addressed, we think, today. Earlier this afternoon, we are concerned about the lack of transparency on capital improvement projects going forward in the future. But this afternoon, we received some documentation from the solicitor's office outlining the 2023 to 2027 capital improvement plan, and so we look forward to looking into that.
Can you please repeat what documentation you received from the solicitor's office?
Yes. Earlier this afternoon, one of my colleagues, who is our point of contact here, Ann Brooks, that she received a schedule of the capital improvement plan for the city of Baltimore for this year, 2023, into 2027. Because we got it, frankly, late this afternoon, we haven't had a chance to dig into it, but we look forward to doing that. And again, thank you very much for the opportunity to come and speak with all of you and to share our concerns, that we really remain committed to working in the city and working with the city to execute a fair and evenly applied conduit access agreement. Thank you.
Thank you. Comcast, former Deputy Mayor Kerstatter, good to have you back. How quickly you've forgotten.
Good evening, Mr. Chair, Mr. President, and members of the council. I'm Dawn Kerstatter, Baltimorean, longtime resident and champion for our city. I'm currently the Director of Government and Community Affairs at Comcast Beltway Region, based here in Baltimore City. I'm proud of my city and proud of the many investments that my company makes and services that we provide to Baltimore residents and businesses, including broadband internet, video, telephone, mobile, and home security offerings. Thank you for the invitation to appear tonight and giving me this opportunity to address some of the questions and concerns of other providers that use the city's conduit to deliver their services to your constituents. As we've stated in prior communications with the city officials and BGE, our goal is to ensure fair and non-discriminatory terms for continued use of the conduit system by all providers to serve the citizens of Baltimore. Along with the questions and concerns that you've heard from other conduit users, I want to briefly identify 3 other areas. But before I do want to acknowledge, just like my colleague here, that we have received initial responses to these questions from the administration, and we've had several promising conversations with the administration recently. So questions from the administration were received shortly before the hearing. I was under the impression that you may have received a copy, as well as we received an invitation to meet with the city to discuss the continued use of the conduit system. We're reviewing the responses and are encouraged by the opportunity to have a seat at the table. Our first area of concern stems from the extensive conduit system work contemplated by BGE's capital improvement commitments under the agreement. It is possible, if not inevitable, that some of this work may disrupt or damage other conduit users' facilities, potentially leading to outages of critical communication services such as 911 calls. Under the city's current lease agreements with our group, if a third-party conduit user like BGE damages the facilities of another conduit user, BGE is responsible for fixing that damage. Our group's current lease agreements expressly immunize the city and its contractors from any liability for any damage resulting from conduit work. By placing BGE into the shoes of the city, the agreement could be read as a fundamental shift in potential risks and costs, where each member of the conduit user group would have to pay for any damage to its network caused by BGE. We would like to clarify if that is in fact the intent of the city. Second, and similarly, under our group's existing lease agreements, if BGE needs another conduit user to relocate its network as part of an improvement project, BGE would have to submit a request to the city, demonstrate that a material public interest supports the relocation, and pay the other conduit users' costs associated with the relocation. By contrast, if BGE were viewed as the city's contractor rather than a third party under the agreement, our group's current lease agreements would require our companies to bear the cost for any relocation requested by BGE, on top of our company's payment of conduit fees. If the agreement were read in this way, it would create an unfair advantage for BGE, since BGE would be able to include the costs of relocating its facilities as part of its committed capital funds for the projects, and in lieu of any separate conduit fees. And finally, the agreement gives BGE sole discretion to engage in future capital improvement projects. There's no provision for other conduit users to participate in the planning of projects, and no requirement for BGE to take any proposals from other conduit users into account. The agreement also permits BGE to conduct its own conduit maintenance. Other conduit users do not currently have that right. Further, under the agreement, the city has committed to prioritize, quote unquote, BGE's permit applications over those of other conduit users. That too would be unfair. And the agreement affords BGE an expedited 15-day approval timeline for its permit applications. Other conduit users do not currently have that right either. In closing, and as I stressed at the outset, our goal is to ensure that all providers are able to share the conduit system on fair and non-discriminatory terms going forward. We appreciate the administration's recent outreach and are confident the council will support and help us achieve an outcome that is a win-win for the city, the residents, and businesses who rely on our essential services, and all of the conduit users. Thank you very much.
Thank you. Now we'll go to BG.
Good evening, Chair Costello and members of the committee. My name is Charles Washington, here on behalf of BGE. I'm the Vice President of Governmental and External Affairs for the company. For more than 120 years, BGE has had some sort of agreement with the city regarding the conduit. The conduit is an important asset for the city and for its residents. For the service we provide, we could not provide safe and reliable service without the conduit. It's also important for the other conduit users to provide their essential services. When we look at this agreement, we see an opportunity, a deal that provides a promise of significant value to the citizens of Baltimore in two important ways. First, the deal allows the investment in the infrastructure to increase in ways that it hasn't before, to provide safe and reliable service for our customers. It also puts downward pressure on customer bills in the city and beyond, so that our most recent filing is over $50 million less than it otherwise would have been without this deal. The agreement requires BGE to work very closely with the city, and it's important to note that the city retains full ownership, control, and management of the conduit system, and has important checks to ensure that it is not BGE's sole decision where investments go, but instead, we will meet with the city every month to discuss investment priorities for the conduit, as we have for many years in the past. In addition, any investment that BGE proposes to the city requires permits from the city before we begin work. That's an important check on our ability to make investments and ensures that the city has a say in what investments we make. In addition, before any work that would apply towards the capital investment goals can be counted, the city must accept that work. And so you have ongoing meetings, you have permitting opportunities, and you have the opportunity to review the work and to accept it or to reject it before it is counted towards the agreement. We believe those checks allow the city to keep the important controls that they need and to ensure that they continue to control the conduit for all of the users of this important system and for the people of Baltimore. I wanted to touch on a couple things that I've heard from other speakers tonight. I'll start first with supplier diversity. It is a topic that is important to me and where I'm really proud of the performance that my company has had in this area. You heard a speaker say that we would suggest that their comments about our supplier diversity program are unfair or are complicated. I don't think it's complicated at all. I think it's very transparent. We're a regulated company. We're required through the agreement that we've made with our regulator to shoot for 25% supplier diversity achievement. We file our performance against that goal every single year, and we regularly, consistently surpass the goal of 25%. In 2021, the filing, which you can find on our website and also on the Public Service Commission's website, that details all the data behind our performance, we achieved 44%. That was $500 million. We have not yet released the performance for 2022, but I'll share with you today that it was 44%. And we go beyond just hiring or giving contracts to minority contractors. In fact, what we found is that sometimes the contractors we want to work with are not prepared for the complicated process of bidding for work with a large company. So we created a program called Focus Forward, which is a supplier diversity academy, so that all those small businesses, those minority and women-owned businesses that want to get contracts with not just BGE, but maybe some of the other conduit users and large companies in the region are better prepared for those opportunities. We're very proud of our work on supplier diversity, and I stand behind it, and I can provide all the data that supports my comments today. I also wanted to talk about what I believe are some reasonable questions that have been raised by the other users of the conduit. And to be frank, some kinds of questions that we may have raised if we were in their shoes as well. We believe we've answered those questions, and I'll say, you know, it was mentioned that there was a meeting yesterday. That was an important meeting to start the conversation on what our ongoing work together will look like. We actually reached out in writing to representatives of the conduit back on February 14th to have that discussion. And we hope that we can continue having the discussion because we're all users of the conduit, and it's important for us to use it together. A couple items that were raised, though, that I can address here tonight. One, there was a question about whether BGE would only make investments that benefit our infrastructure. It's a 9-page agreement. It is a short read. There is an explicit statement in the agreement that our investments must benefit all conduit users. That is explicitly in the agreement. There were also questions about the operational realities of the agreement, questions about notice and about liability. This agreement is a modification of the 2016 agreement, and anything that is not explicitly changed in today's agreement remains in force. And those former agreements—
Can you please repeat that statement very slowly?
Very slowly. Today's agreement, the most recent deal.
The current proposed agreement.
The agreement that we are here to discuss—
Yep.
is an amendment to the 2016 agreement.
Mm-hmm.
And anything that is not expressly changed in the agreement that we are here to discuss remains in force.
But the way you said that, I just want to be clear. I think what you're saying is anything that hasn't changed in this new agreement from the 16 agreement stays in force.
That's correct.
Okay. Just
That
wanted
is-
to make sure I understood it. Thank you.
Sure,
Please
I understand. And so that agreement does address items like notice, like liability, like relocations. And so all of those things remain as they were previously. I've already covered the oversight of BGE. That was the other item I heard that I thought was a good question. I'll just say once more that there are 3 important checks, both the work with the city in advance monthly, the permitting opportunities for the city, and then the opportunity to review, accept, or reject any of our investments. The last thing I wanted to touch on are the allegations that were raised about a former BGE employee. That is a matter of pending litigation, so I can't talk about the specific case. But what I can do is, in the strongest possible terms, let you know that BGE denounces racism. We do not find it acceptable. We do not tolerate it. The employee that was referenced for what they did to demonstrate racism to one of our colleagues has been terminated, is no longer with the company. And we stand strongly behind our employees of color. And I'll just say, you know, what was described today, that is not BGE. That is not BGE at all. BGE is a company where you will find over 3/4 of our executives, including myself, are women or people of color. We're a company that invests over $18 million in nonprofits and in workforce development initiatives in this city. And we ensure that most of those dollars go towards diversity initiatives. We're a company that seeks to partner with our elected government and also with our colleagues in the utilities to do the best thing for the people of the city and to ensure safe and reliable electric service, telecommunications service, or whatever other important utilities are run through the conduit. We think this deal is a really good opportunity, a strong opportunity for the city and for the city's residents to see more investment in its aging infrastructure than it would have seen before, and to see it in a way that puts downward pressure on utility rates. And for that reason, we're very supportive of the deal, of course, and I'm happy to take any questions.
Thank you. Now we'll go to Acting Solicitor Thompson.
Good evening, Mr. Chair, Mr. President, and honorable members of the council. Ebony Thompson, Acting City Solicitor. I had an extensive opening, our first hearing, but I just wanted to add the savings by the construction of this deal that was already highlighted by BGE. It saved our residents over $50 million that would have been passed directly on to them as ratepayers. And during our negotiations with BGE, we went from reaching an impasse that would have likely resulted in litigation to sitting down and developing a creative solution that resulted in securing a historic $134 million investment in our conduit system that will preserve our asset, allow us to retain approximately $10 million annually in maintenance fees, transfer the administrative costs and liability from the city to BGE, all while retaining 100% ownership of the conduit as required by the 2022 Charter Amendment. And now that this deal is approved, we will receive an upfront $14 million lump sum payment, $6.5 million per year more of an investment in our conduit system than BGE ever previously paid, while reducing over $50 million in rate increases for our residents. This is a huge win for the city, and again, I'm happy to answer, along with DOT and Finance, any questions that the council may have. Thank you, Mr. Chair.
Thank you. Is there any other testimony from the administration? Okay, thank you. Start with Vice President Middleton.
Good evening. And my 2 questions on this round. So BG&E did mention that, and you did say liability was assessed. I need you to explain, and I guess the city can explain this too. Who is the city or BG&E responsible for any liability that occurs during this lease agreement? Can you get into a little bit of the detail of this liability that you claim has been assessed?
Thank you, Madam VP. That would be in the indemnification section 13 of the agreement, where BGE shall indemnify, defend, and hold harmless the city and its elected and appointed officials. And this is while they are, I'm sorry, any claims, demands, liabilities, losses, damages, fines, fees, penalties, costs, expenses, suits, and actions by a third party to the extent attributable to bodily injury, death, or destruction of property brought against the indemnified parties, arising as a result of any act or omission of BGE, its officers, directors, employees, or agents in connection with the performance of this amendment that constitutes negligence, willful misconduct, or gross negligence, whether such losses are based upon contract, warranty, or tort, strict liability, or otherwise. Provided, however, that BGE shall not be required to indemnify the indemnified parties for any losses arising out of any act or omission of the indemnified parties that constitutes negligence, willful misconduct, or gross negligence, whether such losses are based upon contract, warranty, tort, strict liability, or otherwise. So pretty much what this means, but this is all in that section, that if they damage anything while they are doing work and we receive a suit for it, they will indemnify us, meaning that if we get sued, they will have to pay it, or they could sue BGE directly. But it is in that section.
Thank you for that. And staying close to my questions, my two questions. Did the Department of Finance or an outside consultant assist in formulating the specific financial terms of the agreement?
That's finance and our finance department. It was collaboration between finance, DOT, law.
Can finance just kind of explain how that took place and a little bit more specifics?
I mean, we worked with law department and DOT to look at the numbers and analyze it. We did not use any outside. We did not use any outside firm to assist.
About how many hours or time? What kind of time period did that take to do all that?
Oh gosh, I mean, months. Goes back many months. You know, as the solicitor said, they've been working on this for quite a while. You know, from our perspective, this is a little bit of a better deal than what we had in the previous agreement, so it's not a massive change really for us. And again, since this is all in a separate fund, it's, you know, users paying for that fund. It has no impact on the general fund. So we kind of came in closer to the end of it just to kind of review the numbers, make sure it made sense from the city's perspective. But we didn't use any outside firm to look at the numbers.
Thank you. Those are my two for this round.
Thank you, Madam Vice President. Councilwoman McCray.
Mr. Chair, I have one question, possibly a follow-up. This may be for the city solicitor, also the finance department. How many meetings were had with the other conduit users? I understand that we talked about a meeting that may have happened today or yesterday, but how many meetings did we have with the other conduit users outside of BGE?
Outside of BGE, I would say in the past month or so, possibly. I can't speak for the actual administration. I can say law has had at least 2 or 3 conversations, exchanged several emails, but for the administration, I think it was a little bit more. I just can't give you quantify the exact numbers, but I know the law department has been in contact.
Director Sinami, Does finance have like other meetings outside of the law with our conduit users, or?
No, we have not.
Okay. BG is saying that they're having a standing monthly meeting. Are the other conduit users going to have some type of standing meeting with the administration as well?
I believe that the administration and also BGE is in discussion with the users on that, and I think what the users referenced in terms of those discussions, and also BGE referenced those discussions, that I think that's one of the topics. Councilwoman.
Can I, Mr. Chair, can we just submit this as a committee request? If a standing meeting is established with these other conduit users, I want to know how often it's going to take place. I think that it would be beneficial that a standing meeting is set up. From the information that you guys provided, Comcast obviously is our number 2 at what, about 7% or something, if I'm going off the top of the information that you guys shared. They're my only source for the internet speed that I need for my home and for many folks within my communities as well. And I want to make sure that these other conduit users are actually at the table as this conversation goes on. So I think that's more of a
Absolutely.
Okay, I'm done right now. Thank you.
Thank you. Councilman Stokes?
Thank you, Mr. Chair. This is more for our city solicitor. Prior to your employment with Baltimore City, did you work with the Venable Law Firm?
Absolutely, sir.
During your time at Venable, did you ever work with BGE or Exelon?
Exelon, yes, sir.
Can you elaborate upon the work?
Sure. I was one of many associates 7 years ago on the merger between Pepco and Exelon.
Do you believe this work do you believe this work is a conflict of interest with you involved in negotiating the proposed agreement with BG&E?
Absolutely not, sir. This is completely different. Conduit was never even a topic of the merger. We never even touched it. And in fact, until Director Johnson showed me what the conduit was our last hearing, I had never seen it. So, no, sir.
Did you request opinion from the Board of Ethics in writing to affirm your decision?
No, sir. Just looked at, confirmed with, and asked one of our attorneys that used to work at the Board of Ethics about that, and they said there was absolutely no conflict whatsoever. They're two completely different, distinct matters.
Mr. Chair, could we have a formal committee request for opinion from the Ethics Board on whether our in terms of city solicitor has a conflict of interest in this matter?
Yes.
So that'll be the committee's, okay, for the whole committee, actually. Thank you.
Thank you. Councilman Schleifer?
Thank you, Mr. Chair. So my question is really for BG, and this comes from a constituent. One of my constituents actually mentioned when talking about this, and we've heard from a lot of constituents about this topic, they said when any business is renting a place, whether it be a storefront or a building, whatever it may be, the craftsmanship and quality of the work that they do is really just to get their needs done. Whereas if you own the building, then you're going to put in the best materials and use the best craftsmanship so that the work will last as long as possible. So the question for BGE, for the record, is when you're doing work, are you going to be doing work as if you're just a renter of it, or are you going to do work with the craftsmanship and level of quality as if you were an owner?
So I just want to be clear that the city retains full control and ownership of the conduit. Our efforts will be to put the conduit in the best possible position it can be in for BGE and for all the other users of the conduit. The agreement is specific that that is the standard that we must meet, but we won't be making those decisions on the construction plan alone. In order for this to be the best asset possible for the city residents, we think it's important for the city to to keep that oversight on the decisions that we're making. And so we're going to do our very best to make it the best conduit. We'll do it in concert with the city, meeting with them, requesting permits, and ensuring that they complete the inspections and accept that the work is to the quality that the city expects.
So you're going to consult with the city on every level, whether it be, you know, the material of concrete used, the type of bolts you're going to use to connect one piece to another. Every last detail is going to be decided by the city?
I imagine there'll be standards that will be set for the work that needs to be completed. I'm not an engineer. I'm not prepared to talk with you about exactly what materials will be used, but I know that in working with the city monthly and in seeking permits and in having those inspections so they can accept or reject the work, that there'll be an understanding on the materials and the level of investment that's necessary.
So, I mean, that doesn't really answer my question fully on, you know, how BGE views it and the level of work and craftsmanship. Clearly, every single day there's going to be decisions that need to be made, both which may be acceptable, one obviously superior to the other one. Usually the superior option costs more. And so how are you going to differentiate between those decisions? Are you thinking long-term best interest of the conduit as if you own the conduit, or are you thinking what is the best decision in the meantime that's good enough so that you can make as many improvements across the system as possible? Because this contract does not include enough money to cover all of the needs of the conduit system.
We will endeavor to make the investments to create the very best conduit system that we can. And so we're shooting for that superior level that you identified, but we're doing it not because we're an owner, but because we rely on that system to serve your constituents and our customers. It's very important that the conduit be in great condition for us to provide reliable service. So yes, we're shooting for that highest level of conduit that we can provide, and because it's necessary for service.
So is that the end game when this contract is over in the future, that BGE is positioned to own the conduit moving forward?
BGE is not seeking to own the conduit. It is not lawful for the city to sell the conduit. What we're seeking to do is to make investments in the conduit that bring the conduit to the best state that it can possibly be, and to do it in a way that puts downward pressure on the rates that our customers pay in this city and beyond for that service.
Okay, thank you. And my second question is for Director Johnson. Do you believe that BGE can perform the improvements on the conduit system better than your conduit team can and has been providing the city within the conduit system?
Okay, so if I could back up for a moment, I wanted to add a little bit more information to the initial question. So in the design review process and reviewing their plans and then issuing approvals for their permits, whatever requirements, regulations, standards that are required for materials and how the conduit is laid out underground, those regulations have to be followed. So it's not a matter where they can just put in whatever and risk the system. And then also the inspectors who have been inspecting our work thus far with the contractor we've been working with, those same inspectors with that same level of expertise and know-how are going to be the ones watching the work that BGE will be completing. And so they will hold them accountable, just like they will hold our contractor presently accountable and direct them to make any corrections, restorations, change up things as needed if there is any type of deficiency found. And then to your second question, honestly, I don't know that I can say would they do the work better or anything like that. There's no assessment, there's no comparison. I know what our contractor has been doing thus far. As it stands with any contractors that are doing work within the city doing the right of way, there might be certain contractors who are better in certain situations and some, maybe not as good. But in this situation, there's really no data or anything for me to be able to gauge who's better.
So you've touched on a few different things. So let's back up to the continuation of the question that you went back to here. That there's obviously a lot within the city code of compliant versus there's the black and the white versus what's compliant, what's not. My question is more in the gray area is what happens with the quality and craftsmanship. So you have the opportunity, if you're renting a storefront, you have to put in a window that meets city code. It doesn't have to be double pane. It doesn't have to be triple pane. It doesn't have to be UV rated. It doesn't have to be a superior window. It can be an inferior window, which is the question that I was getting at to there. So just because something is acceptable by permitting doesn't mean that that's how we as a city would invest in our own asset as such. Whereas a company that utilizes 76% of the system, what they need is that 76% of that system, they need everything that their conduits are touching, which is pretty much the whole system, to be able to perform and for those services to be provided. They don't need to be thinking about, okay, in this situation, if we can only service 3 locations and make the improvements really well, or we can do 4 subpar, that's the decisions that they are going to have to be making and will be making. And so that's my concern that I was getting to, which still remains. But I do have a committee request on that, because you had mentioned the inspectors, is if we can get a list of the names of the inspectors within the Department of Transportation who will be monitoring the conduit system, if that can be provided to the committee. And then to my other question, my question for you was about the level of service that's been provided. I haven't heard from you or anybody in the city, really, that has said that the DOT conduit division isn't doing a great job, isn't providing the services that they should be. We hear that about other functions and different agencies across the board, but I've never heard anybody say DOT's conduit division is not performing at a high level. And so what I'm confused about is, if it's going well and it's working well, why would we be changing that and handing it over and having all of those growing pains that you have whenever a business changes hands from one person to another? There's always those growing pains. You always have different issues that you don't have that institutional knowledge. And so, I guess what it comes down to is, do you believe that BGE will be able to service the conduit system at the same level that your team has been servicing it to date?
Okay.
It's really a yes or no. Are they going to?
No, I was trying to go back through the different questions. So going back to the first point, I believe, any work that is done within the right-of-way, the contractors, whoever that is going to be following our standards, our Green Book, and any other specifications that exist. Contractors, say if I put out a DOT project, certain contractors are going to select, as long as it meets the requirements and they have their source of materials and all the requirements met, they have different vendors, different people they work with. We DOT don't specify in saying that you have to go here, because it has to be the open market aspects of it. So we always ensure that it meets the Green Book, meets all the specifications for the contract itself. That exists with the contractor we're currently working with. We can't dictate specific things or specific materials for them to use. It's a matter of it meeting the contract requirements, and they bid the contract based on that. So they determine where the source of supply is going to be, but our responsibility is to ensure that it meets those same standards. So I can't say that there will be any difference with what the current contractor is using and the materials and things like that versus what BGE will be doing. Also, materials can be verified by catalog cuts from vendor source for PVC, fiberglass, or phenolic resin. Concrete can be verified by the concrete truck tickets and is proved via inspection. And so there's going to be that very detailed quality assurance process that's going to go into any work that BGE does. And again, right now, the different conduit users, if there's some type of a new connection or something else, there are various users who are out there right now adding in sections or aspects to the conduit system. The conduit system grows as developments and things grow and there's redevelopment. And so similar to those situations, people are adding to it. As long as they meet our regulations, our standards, our Green Book, then it's accepted and we inspect the work and sign off on it. So that's no different than this situation. Conduit Division's performance, yes, they've been doing a great job in performing. This isn't a matter of them not performing. This is a matter of us trying to negotiate to get a higher rate. We couldn't get to the rate that we were, we got to an impasse, essentially. And so in this situation, this other creative solution came up to say that they would do this work, again, where it results in $6.5 million more investment into the conduit infrastructure per year. So I know it's something new, but it's something where I see that is going to help improve the conduit system. It's going to lessen the maintenance that long term that the conduit division is going to have to do, and still the conduit division will be doing additional maintenance and capital improvements themselves internally, separate from what BGE is doing. I hope that addresses
yeah,
questions.
just in closing, because I know I've exceeded my time, we're still waiting on the consultant's report. Is that correct, Mr. Chair?
Yes, yes, we are.
So we don't know today what the current value is of our conduit system. And so the way I'll leave it with you is that this is a tremendous gamble. This is, for a little extra money, we are gambling the future of our system in hopes that BGE can perform and their contractors will perform at the same high level as DOT has been performing. I think that's a tremendous risk, and one that I'm not even sure how that decision could be made without that report.
Councilwoman Ramos.
Thank you, Mr. Chair. To BGE, in my district, we have had significant issues with BGE contractors violating ADA, so that there isn't safe passage for somebody to go when there's when there's work being done. We've had significant issues of lack of notice when there is planned work. Emergency work, I get, right? We don't want things to explode, we gotta get in there. Planned work, no notice, okay? And problems with coordinating with DOT and other items, big things going on. For instance, Green Mountain Avenue from 29th Street to 43rd Street. Conduit was going in, new water main was going in, and then we were about to repave it, and one of my businesses said, oh, I saw BGE out there doing surveying. I asked DOT, what is going on here? DOT said, oh no, BGE's not coming in. I called the BGE representative at the time, and she said, oh yes, we're going in next week. We almost had a situation where we wasted federal money because there was no coordination with all of the different work that was going on. And in a black neighborhood, BGE replacing poles in the alley, taking out a pole, putting the debris on a tarp on top of the hole, totally illegal, not supposed to do that, where the truck couldn't get through to pick up the trash. I never saw that in one of my white neighborhoods, but I saw it in a black neighborhood. I see nothing in the 2016 agreement or in this one that says BGE must give notice. I don't see anything in the agreements around ADA compliance. I don't see anything in the agreements about these issues. Is BGE going to finally give notice? Actually, last year, we had a hearing, and I asked for all of the planned projects for the entire year. I got it. I still don't have it for this year, and that should not be my job asking for those projects. Those should be given to us immediately and by district, and a specific designation about what exactly is happening and when, okay? That has to be done. And the fact that none of that is in the agreement about ADA compliance, about notice of work, is startling to me, because the fact that you're going to be going and doing much more work in our city and we're not going to get notice as residents that you're there is astounding. So I'm hoping that, and maybe there's an addendum to the agreement, or that you can write specifically a letter committing. Now, you might say, well, that's part of the permit process. When we get a permit from DOT, they're supposed to tell us this, that, the other. I don't actually care. I think that has to be done with you committing to us that those things are going to happen. They cannot just be because, oh, DOT forgot to put it in the permit. I'm sorry. Even though they're supposed to be, doing the inspection. Another example.
Councilwoman, can we give him a chance to, you very clearly articulated your concern, BG and/or DOT.
Thank you, Councilwoman. You gave me a few things to tackle there. Let's start with coordination. Coordination with the city is built into the agreement. I know that I've harped on it, but I do think it's important that we will be meeting monthly and jointly coming up with the project lists. So we will have that opportunity to coordinate closer to what I think, I hope that you would appreciate for our work. When it comes to notice, I think the concern you raised is a fair one. It's a challenge that we've had on existing work, on our planned work. I recently launched a new team in BGE to try to tackle exactly that. We'll certainly bring that team to bear for this if there were the need to notify your communities or any parts of the city about work that we were doing on the conduit as well. But we are committed to getting the communication with the community right? We do give notice, but I think there's room for improvement on how we give notice. There are methods that work better than others, and that's something we're going to continue to work on.
Flyers. So DPW has to do flyers in everybody's door when there's work. When I suggested that to BGE, oh, it's too much work, there's thousands of people. I'm sorry, get your steps in. Actual notices on the door is super important. Phone calls, people don't use landlines anymore. Emails, not everybody's on email. Flyers on the door. That's the key there, and also letting us know so that we can inform our constituents.
I hear you loud and clear, and to that point on the project lists, I know that my team can hear me when I say we were going to get you those project lists immediately.
Yes, and I need a commitment every single year. You're going to give us a list for all of our all of the planned work, organized by district, as well as the timing of when it's going to happen. And you have to do a briefing with each of us every year as to what the project is going to be so that we can engage and make sure that our residents know. That is critical, and I'd like to have all of that in writing. Thank you. Thank you, Mr. Chair.
Thank you. Councilwoman Porter, and then Conway.
Thank you so much, Mr. Chair. Following on that line of questioning related to the monthly meetings, I want to know if is there anywhere in the report that specifies identifiers of what those monthly reports consist of. So I'm looking at specific items that are shared within each monthly meeting about how many data requests come in. We can also add some, identifiers that's related to upcoming, work that's happening per district. Like, what are the contractual identifiers that you all are going to be reporting out every month from BG&E, and where is that explicitly in the agreement?
So the purpose of those monthly meetings are to plan and coordinate on the capital projects and the investments that will be made in the conduit. And so that is the purpose of the meeting itself. In terms of reports that come out of those meetings, I heard that question at the last.
Yeah, that was one of my questions.
And those minutes are not kept by BGE, and so I'm not in a position to make commitments on what happens with those meetings, with those minutes.
Okay. Do we have an answer from the administration? Yes, ma'am, and I'll repeat my question.
One more
yes,
time.
So I was asking about where is it explicitly in the contract that has specific identifiers for those monthly meetings. One of my committee requests from the last hearing was, one, to get a copy of those meeting summaries delivered to the council. Number two was to see what's actually being reported out with regard to progress contractually for the project.
Thank you so much, Councilwoman Porter. It's in Section 8 where it signifies that BGE and the city shall continue to meet monthly and discuss BGE's capital improvement projects as they have done in accordance with Section 13 of the 2016 settlement agreement. So it's in both agreements, both the new one and the amendment, and also the settlement agreement. And I would defer to DOT on the progress of it because I haven't actually been in any of those meetings.
So one of my concerns is the ambiguity of contract language with regard to what's being reported out in those monthly meetings. One of the issues as a contract manager myself is really understanding what is being presented every month, how we are tracking that for QA, presented out to relevant stakeholders, et cetera. And so is that documented anywhere within either the 2016 agreement and or the amendment that is presented to the council?
The information I know is not documented in either one of the agreements, but I'll defer to DOT if it's documented elsewhere where it's readily available.
Okay, perfect.
I'm not sure offhand if there are, say, formal minutes from each of those meetings. I would have to check into that. But again, like, with this shift, you know, what we're talking about right now, while similar, it'll be a little bit different just because of the transfer of the work being conducted with BGE. But I'll need to verify that. I'm trying to verify. If I get the answer, I'll relay it to you while we're here.
So just so that I'm clear and for public record, for those monthly meetings, is it merely just a check that the monthly meetings are happening every month, or are progress going to be documented during those monthly meetings and presented to the council?
Yes, we can do that, and I know they just recently had one. I think it was last week. Is that correct, Director? The monthly meeting? Was that last week? The last monthly meeting that you had?
I wasn't in that meeting.
Oh, you weren't at that one?
But actually, I did just get a response back. So they said that there are a multitude of different meetings where they discuss the details of projects and the information is presented. It's more of a work session to kind of figure out solutions, but there hasn't been, like, say, formal minutes or anything like that taken down from those meetings. So that's,
Thank you. I appreciate that. Acting Solicitor Thompson, is there an opportunity to add that amended language to the contract, kind of go back to amend this particular settlement? Because again, one of the things that for me I am concerned about is the ambiguity of the contract language and not having a specified list of deliverables specific to what we're reporting out that can be of public record and also presented to the council.
The contract's already been filed, approved, filed with BGE, but we can get you know, the updated minutes if they're taken by DOT and present those to you.
That works perfectly, but more specifically, I'm asking about an amendment to the contract if both parties agree, and it's, you know, of the same line and vein of the current agreement. Is there an issue with going back to the contractual table and adding some specificity to the language that's already been filed between the two parties?
I do not believe so. I think this is our final agreement. It's been filed with the with the PSC. So, but we can make sure that we can get that information if it exists to you. But okay. No, I do not think we can amend it at this point. It's already been filed.
Okay. So if you can help me understand, and Mr. Chair, can I just have a little bit of indulgence here? I just want to really understand the okay, thank you. Yep. So the two parties that, the two contractual parties are between BG&E and the city, correct?
Yes.
Okay.
Yes.
So with regard to the contractual parties, if both parties agree to an amendment to amended specified language, does it again have to be refiled with the PSC? If
that's a question for BGE, because it's PSC.
Yeah.
So I think it would depend on the terms of the agreement,
yeah,
whether it needed to be filed with the PSC.
Yeah, and so that's exactly my understanding as well. So if it's still in the same contractual vein, just adding amended specified language of what those monthly reports are, the reporting schedule, the schedule of deliverables, does that have to be refiled with the PSC?
I'm not prepared to answer that question, Councilmember. I'm not an attorney. I would need to check in with my legal counsel before answering that.
Mr. Chair, can we make that a formal request, please?
Yes. Margaret, you got that? Thank you.
Thank you.
Yep, Councilman Conway.
I'm sorry, I have one more question, sir.
You still have the floor then.
I do, thank you.
Conway, I apologize.
Sorry, sir. I did have a question related to the quality assurance of supplier diversity. Can you walk me through that process of how you all are QAing supplier diversity? So is it merely just a reporting requirement and taking it on face value, or do you all do consistent audits related to supplier diversity within kind of like the program? So I'm looking for not just a top tier level supplier diversity. We have a checkbox, we have minority representation. I am really looking forward to the contractors that come under there. Whether we have suppliers that knowingly to some points, knowingly are exhibiting not good business practices at the subcontractor level, not necessarily at the GC level, but the subcontractor level.
We file a detailed report on our supplier diversity commitment. I mentioned earlier that our commitment is 25% to our regulator, and we do report on it every year. What I'd ask, council member, if you wouldn't mind, is if I could come see you tomorrow and drop off a detailed copy of that amendment so we could talk about what's in it, and to be frank, so I could be sure I'm prepared to answer your detailed questions on it.
Okay, cool. Thank you. Thank you so much, Mr. Chair.
Thank you, Councilman Conway.
Thank you, Mr. Chair, and thank you everybody who actually testified earlier. I think the perspectives of certainly the folks who are in the conduit, certainly BG&E is really, really helpful. I especially appreciated some insight on a question that I had before, but I still have follow-up questions, and that is regarding accountability. Mr. Washington, you said that the agreement has some accountability measures already baked into it. You listed 3. Those were the monthly meetings with the city, 2, still requiring permits, in which case the city could theoretically hold permits, and then 3, that the city must approve the proposal before it would count toward the agreement. And I noted in the agreement we have under Section 7 the blanket permit, expedited permitting. This is actually something brought up in another person's testimony regarding the 15-day period that the city, to the extent any additional city permits are required, the city make all reasonable efforts to prioritize, escalate, and expedite the process for any such permits, and shall endeavor to grant any such permit no later than 15 business days after the date of the application. And then a little further down it says, if any such permit is delayed, withheld or withdrawn by the city, BG&E's failure to perform the work for which such permit is required shall not be deemed a breach or derogation of its obligations under this amendment. Those things sort of seem at odds, and I think what I want to make sure is, these agreements, they're written now, but you write these agreements in order to make sure that when we do disagree, we have a standard by which we're going to hold folks accountable to. I understand some part of this agreement, we want you guys to be able to move quickly, and we don't want to be a burden on that. But when there is a disagreement with the city, it seems that permits is not going to be really that measure to figure it out. So I was curious, in an instance when there is a breach of the agreement, we don't want you guys to move forward or otherwise, how do we handle that, and how does that sort of vibe with Section 7? And I leave that to you and also to solicitor as well.
The solicitor may be better to answer the question because, again, I am not an attorney, but I did want to point out just one additional provision that was not read, that I think is an important one. All those things are provided that the permit application is in material compliance with the city's published written instructions and procedures that are in place on the effective date. I think that's an important provision because it ensures that we're only talking about cases where BGE is not in compliance with the requirements.
Councilman Conway, you were referring just to Section 7. Just what was the specific question about Section 7?
Very specifically, we were talking about, and this is a question I believe I asked in the first hearing about accountability, and my concerns about accountability because there was so much sort of wiggle room within the agreement. Mr. Washington alluded to those three measures: regular meetings, permitting, and approval from the city for any projects going forward. My concern was about permitting given Section 7.
So are you saying what in Section 7 gives you that accountability? Because it's really the standard section I would direct you to if you're looking for specifics on, which would be in the warranty section where it goes into all the materials that are required, that all work shall be performed in all material respects in accordance with the requirements of all required permits, plans, specifications, the City of Baltimore Department of Public Works, specifications for material, highways, bridges. So that's really going into the quality of work and then the accountability would be the inspections that's behind that. But if you had a question directly about Section 7,
so
I could try to answer that.
We can do a thought experiment, and forgive me, I'm not a conduit expert, so I don't know in which case there would be a sort of violation or disagreement on this agreement. And the city has a problem. BG&E has a right after 15 days to either move forward or not. If a permit is rejected, BG&E is still technically in compliance with the agreement. So I was sort of trying to understand in what way do permits serve as a tool or mechanism for the city to hold BG&E accountable to the terms of the agreement? That's really the question.
Councilman Conway,
I was going to say, I was going to say permitting. All right.
Yeah. So one thing, yes. So one thing to make clear to everyone, first of all, regarding the 15 days, I can't remember exactly what the number was, but when we were in the midst of the negotiations, I know that number was less. I personally raised that as a concern, and I said the standard is 15 days. It needs to be 15 days so we're consistent with everyone. And so that was put in there to ensure that they're being treated like others. Additionally, I made it very clear, and that's why the language is in there, that it's not a matter of them coming to us, sending us plans and everything at the last minute and expecting to get a permit in 15 days. The expectation is, and that's what we discussed, is that throughout the design process, they would submit for us for review, they would submit maintenance of traffic, whatever it is that goes a part of that project, that stuff would be kind of reviewed in the process. And then when that day one comes, they submit the permit package, everything essentially at that point has been reviewed, okayed, and we're just going through the formality of approving that permit. And so
let me be clear.
Okay.
I would love for permits to be approved in 24 hours if we could do it. I don't want to create undue burden on anybody trying to do good work in our city, especially with permits. And if we could speed it up, I'm all for it. My question here is specifically in regards to permits being used as a bargaining chip or a tool when there is a disagreement with BG&E. And it was sort of pitched that way by Mr. Washington. And so that's my question. It would suggest here that it really would not be after 15 days. So that was what I was trying to clarify. Is that clear?
I'm not really all that clear. So the way I see it working is that if they are submitting the permit, that means that the city has already kind of okayed it and we're in agreement.
The permit may not be the problem.
Okay.
There may be some other violation of the agreement. The permit may be perfect. It may be, the right work in the right place and the right time, but there may be some other disagreement that we could go through and make one up, or you guys can try one.
Okay.
You see what I'm suggesting? Like
Councilman,
if we say, hey, look, BG&E, hold up. We need to figure this out before you go working in our streets again. That's what I'm suggesting.
You're saying use the permit and hold it beyond the 15 days so that you can get what you want.
Precisely.
I'll turn that over to the deputy. Maybe he has a little bit, or Dan.
Hey, Councilman, real quick. So while the amendment to this settlement agreement is in and of itself, presented to the City Council, it's not in a vacuum, and it goes back in terms of how, back to 1903 with the different agreements. And the two most important ones that I think you would want to know are the 1982 Master Lease Agreement, and just as importantly, the 2004 Memorandum of Understanding between BG and the city. And in that 2004 Memorandum of Understanding, they lay out those standards that are applicable to how BG does its work, the design, construction, and inspection, how they have to conform with the city standards, how they can't deviate with that, and how the city dictates who is in its duct, who has the duct space within its conduits. So it's that 2004 Memorandum of Understanding that if BG does not conform to that, it's not just the holding up of any type of permit, it's that actual Memorandum of Understanding that they have to actually abide by. So it's not, you can't just look at this agreement as a standalone, it's actually in conjunction with the rest of the agreements that the city has had with BG during this time period.
So we'll do a thought experiment here. BG&E's in the conduit using duct tape and bubble gum to fix up our conduit and calling it and I wouldn't assume you guys would do that, but this is just for a thought experiment. They're doing shoddy work. We as a city are not happy with the work that they're doing. We say, look, we want to put a pause on your permits until we have an agreement on what's going on. You're saying that is already understood?
Well, certainly the Memorandum of Understanding, I mean, if that's right, they have to conform by their standards, and yes, we could stop that work from happening. I will say one other thing though. It's in BG's best interests to be doing good work because that's their power lines. So if those power lines fail in any way, then they can't get the energy to the customers, they can't serve Baltimore City citizens and the surrounding counties. So any type of discussion, it's not an outside contractor who does the work and then leaves. This is actually the entity that is going to do the work and then is going to be in the conduit system, using that conduit system to provide the services to the customers, to Baltimore City citizens.
I can appreciate that. We as a city should not assume where BG is going to be in the next 50 or 100 years or 5 years. So I just want to be careful not to just assume that they're always going to do something that we like or the way we like it. And I think that's why these pieces of the agreement are.
If I may add one thing,
yeah, sure.
To the answers that you've received that I do agree with. I think for the scenario that you've presented, that third check that I mentioned might be the most appropriate one.
Okay.
That after the work is done, if the city finds through its inspections that we did not provide satisfactory work, it would reject that work. That work would not count towards our obligation for how much we must invest. And so essentially that would have been work that needed to be reconsidered.
Got it.
Let me also jump in real quick, because he's speaking to the end, but I want to make it very clear that during the physical actual construction, inspectors will be present. They will be seeing the work that's going on, and if they see any type of shoddy work, they will say, stop, this is incorrect, here's a standard, here's a green book, this is what you have to follow, rip it out and fix it. So there will be direct oversight during the construction like we do, on our projects currently. So
that is very helpful to know. So there will be DOT employees on site to oversee these things as they're being done.
We have DOT Conduit Division as well as consultant inspectors that oversee all the work.
Okay. My next question, more of a request if it's available. I've heard a couple of folks refer to a capital improvement plan that would carry us through 2026. Is that complete, or is that being worked on? And is that available to furnish to the committee?
And before you answer that, are you just referring to the city's 6-year CIP?
Yes, it's just this. It's the city's CIP, and because of course fiscal year 23 was approved, it's just the fiscal year 23 through 27 plan.
So just a point of clarification, I think there was some confusion in the terminology that our non-city folks use versus the same thing as the normal CIP.
Okay, thank you. And then this is a sort of philosophical question that I have about the sort of fiscal balance of managing the conduit. I'll first start with, what is the cost of maintenance in the conduit today?
Is the question, what is the current, what are we currently budgeting for in terms of maintenance expenses versus capital expenses?
Precisely, yes.
Okay, we did do that breakdown and provided it, and Director Seneme can provide that.
Just one second, let me pull it up. So,
while you're pulling it up, I'll sort of frame why I'm asking the question, because as I understand it,
for
the
okay,
go ahead, please.
For the fiscal 23 budget, fiscal 23, the operating budget was $13.6 million.
And then what is our revenue for the remaining folks in the conduit?
So one thing, let me clarify, what Bob was just referencing as far as the 13 million, that is the operating budget. That number is not specifically the maintenance dollars. That encompasses the salaries for the staff. It includes some of the maintenance related work materials, things like that. It's a very, I'll kind of say a little bit gray area. So internally we have conduit employees, the field services team, CDL drivers, laborers, things like that, who can go out there and do some type of maintenance work. They do all of that via hand digging. So no mechanical equipment is used to excavate and do that said work. And so if there is truly a maintenance need, but we see that it's something that goes beyond what our in-house staff can do, then it goes to a contractor. That same contractor in more recent years has been doing some capital work as well. So it's a little difficult for us to distinguish specifically between the maintenance dollars and the capital dollars.
I asked that question because we're going to run into a philosophical question with the remaining folks in our conduit. And the next part of that question was...
Councilman, I'm going to ask you to kind of tighten this up here.
Sure. What is the revenue for everyone else? What is our revenue from everyone else in the conduit?
We have those numbers as well. But before Bob provides that, I think one thing that's important as it relates to maintenance costs is that with the capital improvements, once you do a capital improvement, the lifespan is 50 years of the conduit. So the maintenance costs actually decrease significantly with the new conduit. So you'll be lessening your maintenance costs when you do more capital contributions.
Councilman, you were asking how much revenue comes from BGE versus the other?
Really, everyone else is what I'm worried about.
Everyone else. Okay, I'll have to pull that for you and send it to you. I don't have it in front of me.
That's okay.
I have that. I've done this too long, so I apologize for talking so much.
Okay.
Currently it's about $7 to $8 million per year coming in from other users, and that spreadsheet was provided, so we can do that as a breakdown. Obviously, BGE is the largest contributor with the largest linear footage, and then that's followed next by Comcast.
And I asked that question because what we're going to be faced with, and it depends on, of that 13.6 million, how much of it goes towards actual maintenance, and that will go down over time as we make capital investments. BG&E is only contributing to the capital side. The city is still responsible for the maintenance. And so sure, capital's going in, but we still have significant maintenance requirements that we are now taking on as a city, but we're not having enough revenue from our other users. We're going to be in a pickle where we may not be able to meet it within the cost of, within the revenues from.
Yeah. So to clarify that, so what we were showing, what I'd share with you is the budgeted operating cost, which again, it's not exactly, but what we've seen over time is that a lot of those positions that are in the budget, they're not filled. So what we're actually spending is much less than the budgeted 13 million just on the operating side. So, the thing that we've been discussing internally is making sure that, yes, there will be revenue from these other users, will have to pay for, enough staff to be able to do the maintenance, and it won't be the full 13.6. It will be something less than that. And Dan had mentioned, there's revenue about 8 to 10 million coming in from other users. So that we'll have to reflect in next year's budget, in the 24 budget, the true cost of maintenance and the people that are actually needed to do that work. And DOT, it's not unusual that agencies right now have a lot of funded but unfilled positions. So it's just a matter of trying to figure out how many we really need and making sure we budget for those on the maintenance side.
Thank you, Bob. Can we make that a request of the committee? The analysis and the gap between maintenance and revenue from other users, which are going to be our pot to pay for the maintenance. Thank you, Mr. Chair.
One other point I'd like to make just to that also is that in the agreement in Section 9, or the amendment, it speaks to BGE being able to do certain type of emergency maintenance work. So, and it says that the city and BGE will coordinate on that. So there will be situations where, like say right now, everyone comes to the condo division, DOT, to do the work, but BGE would be able to, under this agreement, do those maintenance improvements, and that is above and beyond the money they're contributing to the capital program. Now, if it becomes more of a capital type of work, then that's where it would count towards the CIP that they'll be doing. So they can do maintenance.
Thank you, Mr. President.
Thank you, Mr. Chair. I guess for the other users of the system, have you negotiated a contract with the city yet for your use of the system? I know it expired, I believe, last year.
No, as of yet, to my knowledge, there's been no conversations with any conduit users about new negotiations.
Has the city approached you at all about your contract or an agreement with you?
No.
There's been reference to that conversation beginning soon.
So, but that process has not taken place?
No, it is not.
All right. Is it your understanding that in the original agreement that BG&E as the primary user kind of worked out a settlement, and then ultimately those same terms in that same deal was just applied to you automatically? Is that accurate?
To be clear, we have not heard that clearly or factually. We assume that's the case, but I will speak for Crown Castle. I don't know. I don't want that deal. I want the deal that I have in my holdover agreement that has expired. I don't want to maintain. I want to be a conduit user and pay a fee.
Understood. But the question was specific to the 2016, just trying to make sure we're all using the same facts. In 2016, when that settlement occurred, at the time, BG&E as the primary user of the system, they worked out a settlement with the city, and then ultimately that same settlement was applied to you as other users.
Yes, thank you for the clarification. Yes, that's correct.
No problem. And that agreement was on a per linear foot type of fee schedule or
yes, sir.
Understanding, right? So, okay, just very clear. So at this point, there's been no negotiation, no talk about the agreement. And I hear from at least one that you're not interested in maybe the agreement that's currently in place with BG&E, correct?
Correct.
Right. Now, I have to understand that you all have your own autonomy to kind of pick and choose and develop your contract. My assumption is that maybe there could be a company that's interested in keeping their money and not paying it per linear foot or whatever to the city. And if that is the case, I guess how is that handled, Madam Solicitor?
In terms of what contract, Mr. President?
Yeah, so we are, you guys are amending the original agreement, correct?
Yeah, that was the amendment with BGE?
Yeah, you're amending the original agreement with BG&E, correct?
Yes, with BGE.
And when that agreement was struck, that agreement applied to all the other users of the system.
No, sir. We have individual contracts. Most of them automatically renew with the other users, which is why the our position is that the users are going to have the same rights that they've always had. They have their own individual contracts. But we are, like I said, engaging in conversations with their issues, and BGE is doing the same.
Okay, so it's wrong to assume that the $2 per linear foot, which increased to $2.20 per linear foot, that was struck in the settlement in 2015 and 2016, that wasn't automatically applied to all the other users of the system?
Well, they have to give notice, and then if there's going to be any type of rate increase, there has to be notice that's given, but it's not automatically as soon as BGE signs that all other users are literally signed or bound to the same agreement. Each one of them would have to be given the proper notice.
No, I was just trying to understand the way that it worked in 2015 and 2016, that the settlement from BG&E ultimately applied to all the other users of the network.
It did.
It did?
Yeah.
Is that the strategy of the administration this go around?
Because of the charter amendment, we have to evaluate, and that was in our opinion to you, where it changes things because ones that are going to be expired, there is a question about us renewing it because of the charter amendment where we can't do the franchise. So each individual case, that's why each individual user, I don't want to speak about them universally. We are looking at it individually, but we are having those conversations. But the charter amendment did throw some things into question.
And why didn't the charter amendment hurt this deal?
Why didn't, I'm sorry?
For BGE.
Oh, because BGE has perpetual rights to be there since 1881, as well as Verizon. Those are the only two that can be there no matter what. And it's nothing that we can do, no charter amendment that we can make to kick them out.
So what I'm hearing is that BG&E and Verizon have perpetual rights to utilizing the conduit system, which allows us to develop an agreement or extend an agreement with them, but potentially we're at risk of not being able to develop a new agreement or an extension to an existing agreement with some of the other ones that do not have a perpetual right.
That was our advice, where we would love to amend just that portion so that it is cleaner. We do have some basis to say that we can extend it, but it would be cleaner if that amendment provision was amended again to allow franchising.
Going into the November election, why wasn't the city responsible enough and proactive enough to know that this was going to be a potential issue?
Well, we did, and I think that was something that we talked about before in terms of, I know you alleged that when this came up for the charter amendment that the law department didn't speak up, but I understand that they actually did.
No. I said the law department didn't speak up when the original charter amendment was passed through this council.
Exactly. That's what I was referencing. But at that point, it was already going to be on the ballot. Are you talking about in November?
No, I'm saying so. Under the previous administration, the current mayor was the city council president. Through this body, that charter amendment was a bill, and it passed, I believe, unanimously. And when you look at the bill file, there is no level of any objection or concern that was provided at that time to the council regarding this specific issue that was brought up.
From what I understand, the bill file is only going to reflect if the bill was legal or if the charter amendment was legal. So yes, that would reflect that. However, when it was commentary, from what I understand, I was not here, that Vic Turville at the time did attempt to speak up, and those comments were either shut down or ignored.
Yeah, I guess we can't go back and revisit history if you have no proof of it. We don't have it either. But back to my other line of questioning. So for the other users, what is the strategy moving forward? Because I guess what I was asking was, going into the November general election, the administration and the law department was adamant that this was going to be a potential issue. You were negotiating you were negotiating with BG&E, but you weren't doing anything else with the other users. I guess what I'm saying is, why was that the case, knowing that it was going to put you in the pickle right now that maybe you won't be able to negotiate?
Well, we do have a basis too. It just seems that it would be much cleaner if that amendment was taken out. We can argue, of course, that an existing contract that we can renew an existing contract, but maybe not get a new one if there are new users that want to enter into the conduit system. We would have a more difficult time with that. Of course, we can't do that. So the cleaner version would be to amend that franchise agreement. That franchise restriction on the charter amendment that was passed in 2022.
Understand, Madam Solicitor, what I'm asking is, why wasn't the negotiation with the other users of the conduit system done, knowing that we were running into this train wreck of an issue associated with extending the other users of the conduit system?
Well, I think there's several users, and some of them automatically renew, and some of them were not going to be up for renewal within a time period where we could potentially get another amendment. Meaning that if, let's say, the agreement expires in 2026, we have a shot of being able to get another amendment that would not affect that. So it's all based on the individual users.
Out of the three members who have taken your time and come provided us this information, how many of you are currently under an agreement?
I just want to clarify, there are two different agreements. One was the agreement around the conduit.
Yes.
That was part of the settlement, the Zio settlement case of 2016.
Yes.
We're not in agreement right now.
Yes.
With regard to franchise, we're still in our franchise.
Totally understand. So we're only talking about the conduit agreement now. Would you like to? You're good? Oh, same, different. All right. So the question is, Solicitor Thompson, why wasn't we can just talk about the three here.
Right.
Why did we know we were coming down this path and we were going to run into this issue? Why wasn't the administration proactive in ensuring that we had an agreement in place with them?
Well, it depends on each user. So we do have a basis depending on when they renew. It's just not as clean. It's not like we have to kick all of them out now that the charter amendment passed.
I guess I'm asking, their agreement has expired. It expired last year. When no one knew what you guys were doing, you were negotiating this agreement with BG&E. That's what we learned from the media when the agreement came out a couple weeks ago. The question is, going into that general election, the administration was adamant about this potential issue. And now I'm hearing that based off that, we're in a pickle, we're trying to figure out the right way to move forward. I guess the question is, why wasn't that work done last year when their agreement was expired, and when we knew that that this charter amendment was going to create the issue that we're currently in with them?
Well, we still would have the issue. I guess I'm not understanding the question, because unless we were gonna renew for perpetuity, because we're still gonna have the issue.
What you could have done is at least renewed it to the next charter allotment for us to do the amendment. What I'm saying is that what I'm asking from the law department is, again, I don't believe the appropriate advice was provided a couple years ago. We can't reverse history. But you guys were very adamant on multiple occasions about, if voters went out and supported this, the potential issue around franchise agreements and around what we could do with our conduit system. I'm just simply asking, why wasn't the same level of commitment, of care, of understanding, of being proactive done to the other users, and not just focus on BG&E? It would seem like it would make more sense for the agreement to be worked in concurrently with the other users of the system, as opposed to just focusing on BG&E. Now we have an issue where they're in limbo, we're in limbo, no one knows what's going to happen with their agreements.
Mr. Council President, if I could just add one thing. In terms of prioritizing BG&E, they're something like occupy 30 times as much space as the other conduit users. So there's some sense to why we prioritize them, and I think ultimately why the structure of this deal is actually going to be to the benefit of the other users in terms of not resulting in as much of a rate increase. So treating them, focusing on that first, I think there's a certain logic to that, and I just wanted to add that point.
Definitely understand the logic and understood why the agreement originally with BG&E kind of flowed down to them. What I'm hearing now is that can't be the case for this turnaround. I mean, and they're running their own individual companies with their own individual priorities. And at this point, everyone's in limbo about what happens next.
Right. Well,
that seems problematic. I mean, for it to not to be addressed. I mean, for us not to go down the path of at least having some level of communication with them about this particular deal.
Well, I would just add there's no question we're going to have to revisit that with these other users and negotiate their agreements just like we've done over and over again in the past. I think that we're on a much stronger footing to do that now with the passage of this BG&E, the agreement that was passed last week. So I just wanted to add that. Well, because by doing it this way, a big part of the rationale is otherwise, if we were going to have to pass on all the costs, you were going to have to see a huge rate increase. This is exactly what I think the gentleman from Quantum talked about in his opening statements, is that's bad for them. They don't want that. And so by avoiding that, we're actually putting ourselves in a stronger position, in a more beneficial position for them. So I suppose we could have focused on negotiating the agreements with them before BG&E, but I don't know that it wouldn't have made a whole lot of sense.
Thank you. When you say pass on the cost, I'm sorry, Madam Solicitor.
No, Mr. President, sorry about that. I just wanted to add that all of the different users, they have different expiration dates on their agreements. They all have different agreements. Not all of them are expired, and not all of them will be expired within the time. Some of them are, some of them are not, but all of them are within an agreement.
Understood. That's why we were just focusing on ones here. We know that they're all expired. I guess back to you, Mr. Deputy Solicitor. When you say pass on the cost, what do you mean by that?
Well, so what I think what Mr. Washington mentioned in his opening statements is that by structuring the deal this way, they ultimately were able to save, I think the number used was $50 million in the proposed rate increase, in their rate proposal that was submitted last week. And I think that part of the question is this work needs to get done to the conduit. And if we were instead of structuring the deal the way we did, to sort of go with the structure, that the previous structure, and focused on, instead of allowing them to put more of this money into capital improvements, but have it to entirely be done through maintenance work, that would have required a higher rate to be charged to BG&E. And going back in terms of using that same rate for the other users, that would resulted, again, a higher rate for those other users. So that's what I'm talking about when I say that structuring the deal this way, I think, is ultimately beneficial to those other users as well.
Understood. So what I'm hearing from you is we know exactly what work is needed to be done right now?
What do you mean by that?
Well, in order for you to give me a price about how much something costs, you said it's $50 million. I'm asking, you know exactly what work is needed, and that's why we came up with that, the extra $50 million.
I think that, the conduit system is over 100 years old. I think that it's over $2 billion that it's going to cost to fix the whole thing.
Correct.
I don't think that there's any illusion that that was going to be recovered in this agreement with BG&E.
That's why I was curious as to, I have the same understanding, but that's why I was curious about going down this path of where are these numbers coming from? So where did that $50 million number come from?
I apologize. Can I answer directly the $50 million question? So under the current agreement, BGE makes an annual maintenance payment to the city of approximately 28.125 to be specific,
yes,
to the city. And it goes in front of the PSC and it says, this is my 3-year plan and we need to have these costs. And currently, the last 3-year plan, and I don't want to speak for BGE, if they want to talk in this manner, they can as well. They said, we need $100 million. And then that $100 million was baked into the rate payments that essentially were then absorbed by the entire Maryland, the ratepayers of Maryland for BGE. So if we continued under this current plan, when BG made its filing this, I think, February 17th, it would have had to make a filing to the PSC to say, we are currently still paying this amount of dollars per year in annual maintenance. We need an additional $100 million just for the conduits over the next 3 years. And like the PSC has done in the previous time period, they would have approved it. This time, because we're talking the way the deal is structured for capital improvements, and capital improvements, when you talk about the costs associated with them, they are based upon the lifespan of the capital improvement, so over 50 years. So because you can then amortize the cost over that length of time, BGE can say, well, actually, we don't need to request $100 million for this time period. Our request for that 3-year plan is only $50 million. So that's where your $50 million savings are directly attributed to, and that will then be passed on to BGE's ratepayers.
So it's the amortized amount that's baked in inside of the rate case that provides a level of benefit to the users. Is that what I'm hearing?
Yes, because it's over that length of period of time, that 50 years, as opposed to making annual maintenance payments.
And so BG&E decides whether it's $100 million, $150 million, or $50 million, right?
Well, they have to justify those costs to the PSC. They can't make misrepresentations to the PSC. So when they state, hey, these are the costs associated over that 50-year time period, that is the length of that conduit system, they have to justify that, and that's where that analysis is in their filing that was provided to the PSC on February 17th.
Got it. I guess what I'm saying is when you have a system in such disarray, I mean, billions of dollars in capital costs to kind of fix up, 50, 100 million, 200 million, 300 million, you can always justify the need to spend that money for that plan to fix up, correct?
What I'm referring to in terms of the $50 million is the actual savings to the ratepayers. I'm not actually referring to how much money is going into the conduit system. Obviously, the conduit system is now receiving an additional $6.5 million per year from BGE that will be going into the capital contributions and the improvement of the conduit system. The $50 million is only the savings that is then being passed on through the structure of the deal over that period of time. So essentially what's happening, and these are just the numbers, BGE is contributing an additional $6.5 million more than they previously did, while also decreasing the pass on to their customer base, including Baltimore City citizens, by $50 million. And that's just specific to the conduit system, Mr. President.
Thank you so much. And then last question, this is very helpful. That $50 million in savings, go over that equation again. How do we get to that $50 million in savings?
My colleagues are asking me to pass that question on to BGE, so I will respectfully do so.
The gentleman was doing such a great job.
Yeah.
And he got it exactly right when he explained that there's a difference in terms of the way we account for in our rates, O&M and capital. And O&M, we expect to recover those dollars in near real time, 1-to-1. And so if you invest $28 million in the conduit based on fees from us, we would expect our customers to pay that $28 million.
Hang on 1 second. Everyone's getting it. It's just, I think it's a
Amber Alert.
Amber Alert. If everyone can turn off their silent vibrate on their phone. Yep. Okay, got it. Sorry to interrupt.
Sorry about that.
No, it's quite all right. Under the previous construct, we would recover the costs that we incurred to be in the conduit 1-to-1 in near real time. And so if we paid $28 million in fees as we did last year, then for that year in our 3-year plan, we would recover $28 million. Because we are investing capital under the new construct, instead of recovering those dollars in near real time, we can recover them over the life expectancy of the asset.
Got it.
And so what that means is for like a real bill impact for a city resident, we're able to put downward pressure by over actually $50 million, right? And so if we did not have this deal when we filed on February 17th, the number of our rate requests would have been increased by more than $50 million.
Got it. And that's in line with, I guess, your taxable depreciation as well, or no?
So we've heard the reports that
Yeah,
there's
that's what
going to
I-
be
that's what I'm trying to
some
get at.
tax break from this deal. My tax professionals are unaware of any tax benefit. What we'll say, though, because we're a regulated entity, any tax benefit that does come to us is passed directly to our customers. So while we don't expect a tax benefit, if there were one, that would be a savings to our customers as well.
Got it. Thank you so much for walking us through that.
Sure.
A couple more serious questions. Back to the administration. Thanks for sending the documentation over today. Voluminous amount of information. Obviously, no one has had the ability to kind of read through it or understand it. I guess in that package, does the city show the loss of $7 million or $7 to $8 million that we've heard about over the past couple of weeks?
I wouldn't exactly characterize that way. I think that was a little bit misinterpreted. I think what folks were trying to say was that we needed more investment in the system.
Was it misinterpreted by us or miscommunicated by the administration? Just to be really clear.
Well, I think it was. I think it was misinterpreted because I think what was trying to be said was that we were not investing enough in the conduit system, what needed to be happening. That didn't mean that. That didn't necessarily mean that the general fund, for example, was going to have to dip in tomorrow to make those improvements. It was really, what we're trying to say is we thought we were underinvesting the system, and that this arrangement would allow us to get to a higher level of investment. So I think that's what was meant by that statement, but it wasn't as if like the city was losing or using other funds to chip in and make those.
I think what was actually said in October was that the city's losing $7 million every year under the current agreement. Now, if that's wrong, that's fine, but that was a point of concern of the council because these numbers they just kept changing.
Yeah.
And the issue of how we got to the numbers were contradicting themselves. So,
yeah.
So what I'm hearing now is the city was not losing $7 million a year.
Yeah, and I'll take responsibility for that because I should have corrected that.
You weren't the person that told us that.
I know, but I should have corrected that at the time. But yeah, what we're really trying to say is we were like, you needed more investment in the conduit system to make sure we could, keep the improvements going at the right rate. I think would have been more, clarity. And then this agreement, of course, gives us that additional money to invest in the system.
Thank you. It's good to clean that up. When we talk about the FMI contract, has the $50,000 been paid out to FMI? Does anyone know?
Yes.
It has. What work have we received from FMI?
Well, they did the initial work before it got paused. In trans, they're going to have to basically give us a global understanding now. After we have this massive investment of $134 million, we know that the worth of the conduit is only going to go up. So we have them on a consulting basis through this whole process. So they will be consulting with us as we have that investment go on year by year, because the conduit investment is going to, the conduit value is only going to go up. But we did not finish our consulting with them. They were retained, but it's not finished. And it changed because we were not able to actually get the work done where we could utilize and evaluate different types of options like joint ventures or leases or franchises or anything. So that was taken away, so it just evolved, so now it's more of a consulting basis.
Why do you, in your opinion, feel like that was taken away?
Well, the charter amendment went through, so there was no way to monetize it. If they were evaluating in terms of value where we were going to exchange the value for the conduit system, that option was taken away. So now it's more of a consulting in advisory. As we get these massive improvements, we know that the value of that asset is only going to go up. So we're retaining them.
The same work, Madam Solicitor, has to take place.
Say it one more time, sir.
The same work has to take place. The value, what I'm hearing from you is they're going to be retained as a consultant to help do the valuation of the system. Is that accurate?
Yeah, because after we get this, as we are getting this capital improvement investment, the value is only gonna go up. It's only gonna go up.
I'm gonna be really frank and clear, kind of like the $7 million. This whole deal with FMI has also been misrepresented by the administration. When this deal was originally brought to the Board of Estimates, the administration was adamant that FMI was in place to provide recommendations and findings associated with what we should do with the network. That included evaluation, that included comparative type of analysis associated with other systems, and the whole array of potential options, whether partnerships, whether leases, whether a full-out sale was on the table. I felt like it was a three-card Monte by the administration then, and I still do now, because I think that that was the administration's push to sell the network prior to November, when the folks in the general election went out. Ultimately, I decided to defer that hearing on the Board of Estimates to allow the voters a chance to tell us exactly what they wanted to do with the network, because I felt in my gut that people did not want us to sell the network. Ultimately, obviously, you know that the administration changed the rules of the Board of Estimates. I think because of that, you're going to say that wasn't the case, to allow and to set up where we are today. I guess going back to the original issue with FMI, I don't understand a pathway forward of why it makes sense for us to not allow them to do the evaluation, to do the comparatives, to come up with the best use and class of our conduit system, regardless of the passing of the charter amendment. And I think the administration at that time agreed with me, but it seems like it's changed, because that's why the administration aggressively pushed for the FMI contract to get passed after the voters went out and said they didn't want the system sold. So you can't have it one way, or you can't have it both ways. It's either one way. Either FMI was brought in to provide us the recommendations and findings associated with what we should do with the conduit system, or FMI was brought in to just tell us to sell it. It seems like, depending on whether it was pre-general election or post-general election, the administration has consistently changed that answer. And I think FMI testified to that at the first hearing, that when that they were going down a path of just saying how much the system was worth, because they were basically incentivized to tell us to sell the network. They were going to get 2% of whatever the sale price was. And I think the representative said, once the general election charter amendment passed, the city basically told them that they had nothing else to do. I think he said it came to a screeching halt. So back to the 7%, $7 million, and things happen where we communicate one thing, and maybe we have to change, right? And everybody has space and room to make mistakes or provide information that might not be as accurate. However, to the $7 million, that was used aggressively by this administration, not just to council, but also through the media. When we're talking about FMI, that was used aggressively on the Board of Estimates, pre-general and post-general, for different reasons. And I think that has been kind of the crux of the matter, or the main concern that we've had about this really rushed deal. The reality is we are, 4 weeks, 5 weeks into understanding and knowing what the administration has been doing the entire time. So not really a question, but just the level of frustration, because the administration still to this day can't tell us what we paid FMI $50,000 for. We don't know, we don't have anything associated with the schedule when a report is due. The reality is they didn't have to stop any work that they were already working on, but they weren't working on anything because they were brought in to tell us to sell it, and they were incentivized to tell us to sell it. And then lastly, the problem from an FMI perspective is that even the work that they did, they can't provide us any substantive of work product. This reputable company that has been supposedly working on it, they haven't been able to provide one iota of any substantive work that they've done associated with this. And then lastly, what I'll say is, just because we know that 140 or 150 or $200 million is going in for capital improvements, you don't need to have that work done or completed or understood for you to help to be a variable inside the equation of the evaluation. Like FMI can do the evaluation that they have been doing. They could do that today. They don't need that work completed. They don't need to know whether we're going down Pratt Street or Light Street for them to determine that. And the fact of the matter is, the councilors is really disappointed with the lack of communication, with the changing of answers from the administration, and that we spent $50,000 for absolutely nothing.
Thank you, Mr. Council President. To respond first, it was about 3 or 4 issues. I'll take the FMI one first.
Solicitor, can I just add one point of clarification of the President's question? At the end of your response to his questions, can you just tell us when the work product from FMI in exchange for the $50,000 will be delivered to the city?
The work product? Well, we don't have an end date right now for the consulting. They are ongoing consulting.
Okay,
So
you
we don't
go to
have
the
a.
president's questions, but I'll circle back because I'm just
Okay.
We paid $50,000. We get something in return. What is
Consulting, ongoing consulting. It hasn't, it has not ended. Our agreement hasn't ended. That's what, I was gonna try to.
but there's like a widget or a gadget or something that we get in return, a report, a document. There's something that we have to get for $50,000.
We're getting consulting, and it's ongoing. So it's.
Do they provide written?
We have not gotten a written report. We've answered that one already. We have not gotten a written report. That's why it wasn't provided to you. You asked for that. We don't
I
have
saw
that.
But like, I'm just struggling with. We paid $50,000 for a thing, a service, a consulting service. When do we get a tangible thing in return for that? A report, a piece of paper, something that says what they've been doing or consulting on. I don't understand what they're doing.
Well, the scope of work was provided to you, sir. So that's what they're consulting us on. Now that part we did provide to you, and if you don't have it, I can have that sent back over to you. But it does list the scope of work.
But do they send like a memo, like this is what we think you should do, like because we're consulting you?
Well, the situation changed, sir. Once the charter amendment passed, it changed, but I can tell you this: that FMI was never retained to assist us with a user fee, similar with BG&E, because that was the question. How come we haven't waited for the FMI results for the user fees? That wasn't what they were retained for. It's for a global understanding of what we can do, because as we have this charter amendment, there are certain users that may not want to renew because of the advancements in technology, right? They may want to go satellite. They may want to do directional boring. There are different things of how we can utilize our conduit system. And with this change, there are various things that we need to ask and consult them for. It's just not over yet. So I can't say, how long we're going to be in consulting with them. But I do know that there's a massive investment that's going to be taking place in an asset that we own, and we can have different evaluations, especially if we are thinking about amending the charter again to allow us to go into franchises. That would open something else up. So we believe that there's a value in having them there for a global understanding of the conduit system, especially because we're preserving the asset with this massive investment of $134 million. So we think it's very valuable. But to touch back on the other point about this $7 million, and I know the deputy spoke on this, but I want to be very clear that there was more money going out that was coming in, and that was confirmed by finance. The law department did not make that up. It's just that DOT had, from what is explained to me, they had a large checkbook at the beginning. I'm sorry, they had a large amount, a balance in their checkbook. So because they started out with a lot of money, that didn't mean that more money wasn't going out than was coming in. That's how it was explained to us, so we did not misrepresent you when the law department stood up and said that that was the figure. Those figures only came, we do not pull those numbers out. Those numbers came from finance or DOT. We don't make those numbers up. So I do want to clarify on that point.
I guess to that point, so what we're saying is under this new agreement, less is going to go out and more is going to come in?
For this agreement? No, the updated, this is $134 million investment in lieu of the $28 million that BGE was formerly paying.
I think the bigger cost is the maintenance. Like, we're still responsible for the maintenance. Is that accurate?
Yes, but the maintenance is going to go down as those capital improvements go up that I think Mr. Goldberg addressed earlier.
So I guess the question is, based off your projections, more is going to come in than is going out. I'm only saying that because that's what you said was a concern before. That more that was important for us to understand that more was going out than coming in. What I'm saying is, does this deal change that?
According to finance, it does.
Yeah, just to clarify one thing, I think going back to this losing money on a cash basis, I think the numbers you Louis looked at, we went into the prior BGE agreement with a balance. And so there were years that we had money in reserve to start that last agreement, and there were years where we spent more in cash than was brought in on that particular time period. So but we had the money. It wasn't like we were spending money we didn't have. So I think that's what got kind of misinterpreted. And then kind of in the broader context of like we need to invest more in the conduit system and make sure we keep the asset in good shape so that it doesn't deteriorate and it doesn't lose value. I think that's why that statement kind of got misinterpreted. But yeah, if you look at any individual cash flow year statement, there were years that we were spending more than we brought in, but that doesn't mean that the city was losing money as a whole, if that makes sense.
No, it makes total sense.
Thank you, Mr. President. Can you talk about the methodology behind how you came up with the figure of $50 million in savings? We had a very extensive hearing 2 weeks ago, and tonight is the first time I've heard that figure.
Can I ask you to clarify your question just a little?
Absolutely. 2 weeks ago, when we asked for the justification behind this deal, this proposed deal, the administration stated that we would be getting $6.5 million more per year over a 4-year period. Is that correct? I'll take the nod, that works. And tonight, we heard from both BGE and the administration that we will be saving $50 million.
I think I understand your question now, and I think we are discussing two very different numbers. One is the amount that BGE will invest in the conduit system.
That's the 6.5.
That's the 6.5, that greater than the 28 million we paid in fees last year. The other number that you're discussing is how we as a regulated company recover our costs through our rates. And because we're using a different accounting mechanism, we're accounting for capital instead of O&M. The way that is reflected in the bills that our customers pay is that it's spread over more time. And so for the bill that customers would receive in the mail beginning in January 2024, there's been downward pressure of $50 million or more because of this agreement. Because we're accounting for capital instead of accounting for O&M, the way that we're talking about the details of regulatory rate making for utilities. It's complicated, right? And I'm oversimplifying it by necessity, but because it's capital, it's spread over time, and there's a lower rate impact.
Thank you, that was very helpful. I would definitely be interested in looking at some type of documentation that explains how this proposed agreement provides for $50 million in savings to ratepayers. I certainly understand, it's clear as day, that the city will be getting $6.5 million more per year from BGE. I see that piece. I don't understand the $50 million. What I do understand is that on February 15th, the administration attempted to ratify or approve the current proposed agreement with BGE. And 2 days later, BGE submitted its base rate case submission to the PSC on the date that BGE had requested to be able to submit their base rate case submission. That wasn't dictated by the state, wasn't dictated by the city. I understand why around that time was dictated, because it takes approximately 10 months, but let me go back here. What we do understand is after the action the administration took on the 15th, 2 days later, your base rate case submission, which includes justification, which of course included this proposed agreement, resulted in an increase to ratepayers of how much?
Our revenue requirement was $602 million.
So what was the average increase to ratepayers? I think the Sun and the Banner reported it, right? It's like $10 a month?
In that range.
Okay, so we have a current agreement in place. You asked for this new agreement that has been proposed with the city, and as a result of that, ratepayers have to pay $10 more per month.
That is not true.
Please walk me through.
Sure. Because the truth of the matter is that were it not for this agreement, that number, that $602 million revenue requirement, would have been over $50 million more. Because we come to the Public Service Commission with we call it a revenue requirement. You can think of it as the amount of money that we need to make the investments in our system that we need to make.
And that's to break even, right, if you will?
It's the amount of money we need to recover from our customers to make those investments and to be able to earn our regulated return.
And it's like 9%?
In that range, sometimes,
Okay.
Yeah, in that range.
That's fair. You're not a nonprofit. I get it.
Sure. And so if we had, let's say the agreement was not enacted. In that scenario, we would have been expecting to pay what we paid last year, $28 million a year for the 3 years of our multi-year rate plan. And we would have been expecting to recover those dollars one for one over those 3 years. Because we would have needed to recover all of those dollars, that would have had a higher impact on the bill that you receive in the mail for those 3 years than the model that we opted for in the new agreement. And so the revenue requirement, as we discussed, would have been up over $50 million to be able to recover the amount that we were paying in O&M.
How long have you known that this would result in $50 million in savings to ratepayers?
How long have I personally known the exact figure?
BGE is what it is.
What I'd say is that our regulatory team is pretty bright, and so they understand the impacts of the investments we're making. I don't know when they knew the exact numbers, but they would have been paying attention to that throughout the negotiations.
It's safe to assume that they knew it prior to agreeing to this proposed agreement in principle.
I would make that assumption, but I don't really want to.
No, that's fair, but it seems like a safe assumption. I don't hear you vehemently opposing that assumption. So if that's the case, that must have been communicated to the administration.
I can't. If that is a question, I cannot answer it.
So if a reasonable person could conclude that BGE folks knew before they agreed in principle to this proposed agreement that it would save the ratepayers, according to BGE's methodology and calculations, $50 million per year, BGE must have communicated that at some point to the administration. Was the administration, when was anyone aware that this would result in?
May I make one clarification?
Sure.
It's $50 million over our 3-year rate period,
3 year.
not $50 million a year.
Right, so it's, sure, 16 and 2/3 million.
Sure.
Got it.
I can just say that $50 million number isn't something we had. I know that the idea was made very clear to us. I think that, BG&E was preparing the rate filing as we were negotiating this. So the $50 million was never made clear to us, but I think the idea of that savings was made clear, and I think fortunately we, had faith, and that was showed to be justified by the proposed filing from last week.
Actually, I can just add to that. So prior to their filing with the PSC, BGE is not allowed to publicly disclose or to publicize that information as to what the actual, because they have to provide that information and it's all lining up, so they can't actually disclose specifically what that information is. So, but the cost savings, and I think actually during the, was it February 14th when we were here last time? No, that was Valentine's, because I should remember Valentine's Day. But I think the solicitor at that time did discuss how the using capital contributions was going to decrease the costs that were associated with the users at that time, but we didn't have that specific number, which was the $50 million over the 3-year time period you just referenced, Councilman.
So, at any point, did anyone from the administration during these negotiations ask BGE what the impact of this proposed agreement would be on the ratepayers?
Yes. Well, by structuring the deal this way, we knew that it would have less of an impact because they were going to be able to capitalize it instead of just how Mr. Washington explained. Instead of it being one-to-one, it can be over a period of years. That would be less of an impact on ratepayers, and we knew that, but we didn't have the specific number of $50 million.
So we knew that this proposed agreement would result in ratepayer savings, but we didn't know the figure. Did we ask what the figure was? Because I assume there's some type of NDA in place during negotiations between the city and BGE.
We were told at that time until they figured out the whole filing, because I understand that's a very tough process. I'll let Mr. Washington speak to that, but no, they didn't have that exact figure, but we knew that it was going to be and that was a factor in us doing this deal, that it would be a savings to ratepayers.
Wouldn't that be relevant information to have prior to agreeing in principle to the proposed agreement?
We knew that it was going to be less of an impact than one-to-one than what we had. We were better off, and we were getting more money. So, yeah, we were up.
Okay. Mr. Washington, correct?
Yes.
Is there documentation that BGE can provide to the council that outlines that methodology for how you came to the figure of $50 million over a 3-year period?
There definitely is. There are mountains of documentation of everything in that filing.
I believe that we got 490 pages of emails today from the administration at 2
And it's
o'clock.
not done. It's not even close to done. I was on my way during your earlier line of questioning to making a commitment. I think it's my 3rd commitment to council members today to come in and speak with you about it, because I could send it to you, but it takes a regulatory expert to be able to explain it.
I would love the opportunity.
I would love to bring an expert in to kind of walk you through the math.
I think we would love the opportunity to have that conversation with someone from the regulatory/financial side. Let me switch gears for a moment. Madam Solicitor, we had discussed at the last hearing 2 weeks ago that there is an opportunity available for a jurisdiction and a utility provider to jointly request a deferral in an instance similar to this, where BGE's rate schedule expires at the end of the year, right? And it takes 10 months approximately for the PSC to review the base rate case, right?
Yes, the statutory timeline they have is 300 days.
Yep. So we're now aware, right, that we could have made a joint request with BGE to defer this to kind of clear up some of the confusion that's been created in the public forum, right?
No. I did look into that because you said it and it sounded off. And I confirmed that there is, I don't know of a jurisdiction that has done that. And if there is a jurisdiction that's done it, it's not a major jurisdiction here. And I confirmed that you cannot do that. And it hasn't been done here. So I did look into that because that sounded really off when you said it 2 weeks ago.
So I got that from a pretty authoritative source.
Okay. I would love to know what jurisdiction it was.
Yeah, it was the chairman of the PSC that told me that directly.
From Maryland?
Yes, the chairman of the PSC for the state of
And
Maryland.
do you know the case that actually?
I don't know the specifics, but I will.
I would love to get that because I was told that that cannot happen.
I'm not going to publicly disagree with our chairman, but what I'll say is we are under an obligation to have a rate approved and implemented by January 2024. And when you start to count backwards on the 300 days that the Public Service Commission has to fully litigate or to have the case fully litigated before them and to rule. You basically land in mid-February, where you need to file in order to get the conclusion in time to implement by the beginning of January. And so I don't know what the chairman had in mind when he said that to you, so I won't disagree with it. What I'll say is I can't see a way that we could have filed after mid-February and met the obligation to have the rate in place by January 1. I thought that was my general counsel.
Okay. Has BGE ever made an offer to purchase the conduit system from Baltimore City?
I've heard of rumors, but I am not, nothing has ever been confirmed, but I did hear rumors about that, but we haven't been able to confirm that. That's another thing that we were trying to confirm, and we couldn't find any documentation on that, sir.
That's something I'd have to talk to the team about and get back to you.
I'd be really curious to understand if that offer has ever been made. My understanding is if it was made in the 2015 to 2016 timeframe. So if you all could look into that, I'd be very curious to know, because I think an offer of that nature would help justify how some of these concerns have been colored here as to giving up control of the system, just generally speaking, if that makes sense. I mean, is it an asset that BGE wants? I think that's, I'm not asking you to answer that now.
I think you can ask.
Well, if you want to, I don't want to put you on the spot, Mr. Washington. I think what I'm getting at is I'm trying to understand if it's an asset that BGE has previously expressed an explicit interest in controlling.
I didn't work for BGE in 2015. What I'd say that we want is the deal that we struck with the administration. We want to be able to see the conduit that provides service to our customers invested in at higher levels. And we really appreciate the opportunity to do that in a way that doesn't reflect in higher bills for city residents. So, that's why we negotiated the deal that we did. And that's what I can say today.
I appreciate.
Regarding bringing that discussion into this time period, has BG&E spoken with the city or representatives of the city, like a consultant, about potentially purchasing the network?
I'm sorry, what was that question?
Talking about this time frame, not the 2015, 2016 time frame. I think it was reported that there was an attempt to buy it for like $100 million at that time. But talking about this time frame now, has BG&E spoken to the city or representative from the city, like a consultant, about purchasing the network?
So the conversations I'm familiar with are the conversations around negotiating the agreement that expired last year. And I know that there's been a discussion of what the terms of that agreement could be, and what we landed on was the agreement that was before the Board of Estimates last week.
During that negotiation, was there ever talk about BG&E purchasing the network?
So I'm not a party to the negotiation, and so that's something I'd have to ask, and I can't commit that I'd be able to share the details of the negotiation. I need to talk to my counsel about it.
Understood. To the city, could you, Madam Solicitor, did BG&E work with FMI, work with anybody on our behalf, or work directly with us in talks about purchasing the network?
So I'll answer that just because I think I was a little closer to this than the solicitor at that time. And I mean, I think back when we were originally, and frankly, this will be, I think, in the very initial conversations with FMI, all different options were at least considered, but there was nothing that was formally considered. No proposal was made. No serious, progress was really made on that.
Got you. And FMI's work was at that time the same it is now to just do an evaluation for a potential sale. Is that accurate?
I mean, at that point, we didn't even have an engagement letter with FMI. I mean, this was when we were just originally doing basically the outreach to FMI to bring them on. So all these, I just want to be clear that to say that, you know, the concept never even was raised. I don't want to say that just because when we were first talking to FMI, I think, you know, all of these, I mean, all of these different ideas were sort of thrown around, but nothing formal or nothing more concrete than that.
Did FMI provide the administration a number?
No, not to my knowledge, not anything formal, not that I'm aware of.
Mr. Chair.
Thank you, Mr. President. Is everyone familiar with what an as-built plan is? So an as-built plan deals with any type of construction, and it essentially, and anyone can feel free to correct me if I'm wrong, but my understanding of it is it's essentially a drawing of what you have and then what it looks like after the work is done. Is that fair? An as-built plan for Fayette Street, let's say there was no street lights on Fayette Street, right? Be a drawing of Fayette Street with no street poles on it, and then someone comes in and does the work, and then it's a drawing of Fayette Street with 6 new light posts. I think I'm oversimplifying it, but so, Mr. Washington, you had mentioned in your opening testimony that discussion around permits and the fact that DOT or the city has to approve these permits. And Madam Solicitor, I brought this up during the previous hearing, and I said I was going to come back to it, and we were like 3 hours and 15 minutes into it, and I never came back to it. So I thought now would be a great opportunity to—
It felt like you did.
Yes, I didn't forget. It's in my notes. And I want to refer you to Section 6 of the proposed agreement. Notwithstanding the foregoing, the capital improvement projects, I'm at the end of paragraph 1 under Section 6. Notwithstanding the foregoing, the capital improvement projects shall be in support of and connected with the facilities, and B, BGE shall determine in its reasonable judgment whether to pursue any specific capital improvement project. It goes on to say, upon the completion of each capital improvement project by BGE, BGE shall provide the city with as-built plans prepared in adherence to city requirements. BGE will submit its inspection results to the city for its review and approval. BGE's work shall not be deemed to have been accepted until such plans have been received and approved, and all inspections have been satisfactorily completed. Such plan approvals and inspections not to be unreasonably withheld by the city. And I'll just jump to Section 8, which I think has relevant language. Notwithstanding the foregoing, BGE shall determine in its sole discretion whether to pursue any city capital improvement programs and will notify the city regarding same. So I've struggled to understand the assertion that has been presented by both the administration and BGE that the city retains control over which work BGE does and doesn't do. That language to me clearly indicates that BGE gets to decide in its sole discretion, I'm quoting language from the contract, BGE can then go out and complete work, and then after the work is completed, then they seek approval from the city, right? So like I deal with land use all the time on the city council. So like when someone builds a rooftop deck illegally, right? They have to go back and get permits for it, and then they have to get it inspected. But like they didn't ask for permission, they just went and did this thing. Does that make sense, what I'm trying to get to the bottom?
It absolutely makes sense, but you got to keep reading on paragraph 8, because it says that the BGE and the city shall continue to meet monthly and discuss BGE's capital improvement projects as they have done in accordance with Section 13 of the 2016 settlement agreement, meaning that it's referencing the course of dealings between these two parties. The course of dealings over the last 6 years is that they meet monthly, and at no point have they disagreed on the capital improvement plan, and that's a big part of what goes into this, because at that meeting, we know what we're going to do. So it's not like they just go out, they just do the work, sort of like the rooftop deck, and then we just go out and inspect it. We know the work that they're going to do. And then we have the right, pursuant to the section that you read in 6, the second paragraph of it, that they shall not be deemed to be accepted until such plans have been received and approved, and all inspections have been satisfactorily completed. So, yeah, you're parsing it out, but you gotta read those entire paragraphs, because that would give us the full picture.
So, I'm not gonna defeat you in a legal debate because I'm not an attorney. But what I heard is that historically, BGE and the city have met monthly per the 2016 agreement. And historically, since 2016, BGE and the city have never had a disagreement about what work is to be done. So let me give you another common person analogy. If I go to a bar and order a drink and a burger, and it's the bar that I go to every week to order a burger and a drink on one Thursday night, and they trust me that I'm going to pay my tab. And every Thursday night for 7 years, 6 years, I pay my tab. That does not preclude me from walking out tonight and not paying my tab, just because historically I've done that. And I think I'm trying to articulate the concern that members of the president and the comptroller, as well as other members of the council and of the public, have, that this language permits BGE to do more based on what they want to do. That's not to say BGE is I'm not implying that your character as a company. My issue is with the language in the agreement, if that makes sense. And I hope I've not articulated that in a way that makes you feel like I'm not trusting of BGE. What I'm not trusting of is the protections in the agreement for the city of Baltimore.
Yeah, to that, I would just say that this is where the trust doesn't, it's not so more in trust, but where you align your interests. Whereas BGE occupies 76%, we can't forget that. They are the largest occupier, and they are literally everywhere in our conduit system. So if the conduit system is going down, and as we all recall from when Director Johnson brought in what the old terracotta in Orangeburg looks like, and then what, and their workers are in there too, and those are legitimate concerns. So that condition affects all of the users, the entire conduit system. So our interests are aligned in wanting these capital improvements done because everything is there. To your example would be if you had an ownership stake, right? It's like if you got something from that, or something was in that bar that was valuable to you, that you had, and you wanted to protect it, you probably wouldn't steal from it, right? So I think that's sort of where where we're looking at how our interests are aligned, and it goes beyond just, oh, we trust that you've done it for 6 months. It's just that we have the same interest in making sure that the conduit system works. And this was just a reconstruction of this deal so that we could get more money out of it. And it also allowed BGE to capitalize it, and the ratepayers and the residents all benefited. So it's just a win-win, and it's a great public-private partnership. But that's how I would characterize it, but I see your point, sir.
I appreciate that, and I'm going to come back to one other thing on the financial side in a minute. Mr. Washington, you indicated that BGE on February 14th began to reach out to our other conduit users to talk about meetings, I think, or was that the city?
Conduit users.
Okay, but that was BGE, not the city, correct?
BGE reached out to the conduit users, yes.
I certainly appreciate that and appreciate how critical the service that BGE provides in the conduit is, because the reality is that none of these conduit users, their purpose in the conduit is useless without BGE's electric, right? Like, I can't turn on a TV with Comcast and use that unless I have electric. I can't turn on my laptop and use broadband internet if I don't have electric, right? So I want to recognize the importance of the service that you provide. I hope that there's a more collaborative spirit moving forward, as opposed to them hearing about it one day before what the administration did at the Board of Estimates, if that makes sense.
Yeah, I think we're interested in having collaborative conversations with the other users of the conduit. You know, they provide a critical service as well, one that's necessary for all the city residents. Sure, our service empowers theirs, but theirs is critical. And you know, I mentioned earlier that I thought that the kinds of questions that I heard to me when I finally got a copy of their letter, that was actually what led to my outreach. I got a copy of their letter, they provided it to us, and it made me think that maybe there was an opportunity to clear up some of the questions, and that was the purpose of the outreach. And they did get back to us right away and say that they were going to review some information they had at that time, and that we would have an opportunity to speak, and we have. And so we'd like to continue those conversations, and we do believe it's important for the conduit to serve all of the users.
I appreciate that. I've only got one remaining question. Madam Solicitor, if you could pull out the proposed agreement. Actually, I have two. This one's the long one. The next one is very quick, and I'm done. So in Section 3 of the new negotiated agreement.
$120 million investment?
In Section 3 of the new negotiated amendment agreement, it says BGE shall be responsible for and undertake itself and through its contractors capital expenditures related to capital improvements up to an aggregate cost of $120 million during the initial term. And in parentheses, it says in bold, BGE initial term CIP obligation. And then in Section 5, once again, in the new negotiated amendment agreement, similar language is used. Quote, BGE shall A, be responsible for and undertake itself through its contractors capital improvement projects up to an aggregate cost of $92 million, end quote. And once again, in parentheses, it says in bold, BGE extended term CIP obligation. Okay, now in Section 4, paragraph 2, is here that we find the agreement of remittance of payment that the administration has touted as the backstop for the city as guaranteeing certain quantities of work from BGE and thus be compensated, the city be compensated, if that work is not completed. In the event that BGE does not spend the entire amount of either BGE's initial term CIP obligation or BGE's extended term CIP obligation, all amounts not expended or not otherwise earmarked and committed for capital improvement projects then under construction shall be paid to the city by BGE as an additional maintenance payment or an additional extended term maintenance payment as defined in Section 5. So, given the use of the language up to in each definition of term obligation, there doesn't seem to be a floor for the expected value of work from BGE. Based on this contrast as written, it seems that BGE's obligation for each term is not actually $120 million or $92 million, but rather a range of 0 to $120 million and a range of 0 to $92 million, respectfully. Now, in the initial agreement from 2016, the rental fee per linear foot for 2020, 21, and 22 equated to $27.5 million, which included a rental rate of $2.20 per foot, which meant that the per linear foot payment could have grown to $28.6 million, upon which it was capped. So why convert a flat rate that isn't guaranteed in this new agreement when we were receiving a fee that could increase from its base? Why not negotiate with the same or similar structure? So it seems like my reading of that, and perhaps you all can correct me, it seems that the city is set up to potentially lose millions of dollars and subsequently impact to the ratepayers.
No, sir. So the up to amount is taken into account, from what I understand, and I've had to have a crash course in it, is that it takes a long time if you're going to do capital improvements in terms of designing and planning. So I think they have to do the planning for it, and they actually have to do the work. But the up to, it is in, again, aligning our interests. Again, this is where I think we should really focus on, is that BGE, for this whole capitalization, in order to do that, that's where, if they are able to utilize this money as capital improvements as opposed to maintenance, that's when they can do the capitalization and they can draw it down for over years. So they want as much money of that 120. 14 million is upfront, and we acknowledge that 14 million is upfront. That's really a transition period for the maintenance, but the 120, they want as much of that to be capital improvements so they can amortize it over a long period of time, and that's also benefits the residents and the ratepayers. So I would say no. And then if this was the only thing that happened, this was the only equation that was factored in, where it was just the improvements. It's also the transfer of the administrative costs. It's also the transfer of the liability, which for us is a huge thing, because we've seen the condition of the conduit system and some of those parts, that if that crashes a catastrophic failure, instead of it coming on the city, that goes over to BGE. So there are several factors that go in, not to mention that the one that we can now quantify, which is $50 million that the ratepayers would have, and our residents would have saved, what they would have experienced in a rate increase, but because we structured the deal this way, they realized a $50 million, a little bit over $50 million. So this is not the full amount. You would have to factor in all of the added benefits for the structuring of this deal, and we think that it far surpasses what we were getting from BGE in a maintenance payment, $28 million annually.
Mr. Chair, if I may add to that. Because I think I understand your question, and I would say to you that there is absolutely a floor, a hard floor of what we will invest in the system, and it is $120 million over the initial term from a capital perspective, plus a $14 million investment in the first year of the term, plus $1.5 million each year for the 3 years. The language that you've locked on to, the up to 120, is about direct investment in the system. But in Section 4, what you were reading is essentially a requirement that if we did not do 120 in that initial term, $120 million to be clear, then we would be required to make a lump sum payment at the end of the term for the balance of the 120. Okay. And so the full commitment could not be avoided. We must make $120 million in investments in the conduit during the first term, the initial term of the agreement, is the way my legal team has described it to me.
Got it. My last question is for you, Madam Solicitor. Law Department represents the mayor and city council, so I want to be clear that I'm not asking your position or your agency's position. The position of the mayor's administration is that on February 15th, this agreement was, is it ratified or approved?
So sorry,
Okay.
Approved,
So it's the position of the administration that this agreement has been approved, and it was done so on February 15th, correct?
Yes, sir.
Thank you. The comptroller has placed this item on the agenda for the March 1st Board of Estimates meeting. How are you going to advise the mayor and the director of, well, I'll just say the mayor. I mean, the mayor gets legal advice from you.
Yes, he does.
Are you going to vote on this on March 1st?
Yeah, I don't have any problems voting again on it. We've already voted on it. It's passed, it's filed, it's done. And I've issued an opinion to Mr. President that I hope that he shared with the rest of the council. Yeah, this deal is done, but we can vote on it again. Yeah, we can vote on it again.
I guess I'm curious as to what's the utility of voting on it again if your position is, let me start over, please pardon me. From the perspective of the administration, what is the utility of voting on it again if the agreement has already been approved?
Well, we actually respect, and we wanted we wanted everyone there. We didn't want to have to pass it this way, right? But our BOE rules in our city charter would not permit someone to intentionally just not show up to stop city business. So we still would like everyone there, and we still would like the full body there. So for that utility, it's definitely value there. But yeah, or we cannot. It's so it could be the first. It could be a special meeting, but it's already passed. It's already filed. It's done as far as we're concerned.
Understood. Appreciate it. Before I turn it back to the president. Well, I'll turn it back to the president, and then we can close out.
I just have a couple quick questions about competition in the future. I guess if a current user has to perform work, I guess they have to come to BG&E, or how does that work?
Can you restate that question?
I'm ABC Company. I provide broadband communication, and I need to put additional facilities in a conduit run next year. Where do I go?
So the process won't change. They're still going to come to the city, come to DOT to go through the permitting process like they would, a year ago. And anytime anyone does any work, we're always looking to make sure there's not any type of conflicts or things like that. So there might be some coordination just to ensure there's no conflicts, but that process doesn't change. They wouldn't go directly to BGE for it because the permitting comes through the city.
Understood. Will BG&E provide the other users information on the capital construction projects that they have planned out?
Will BGE, I'm sorry, you said will BGE provide what to the other users? I'm sorry, Mr. President.
Capital construction plans. So we keep talking about this large investment, the work that will be done on those large investments. Will Comcast know?
So I think that's a conversation that started, right? I've heard requests from the other conduit users to attend the monthly meetings. I've heard requests for us to get together and talk about investments in the conduit together. I think that there's a commitment from BGE, and I think it's shared by the other conduit users to continue conversations. I think those conversations will determine how that coordination happens in the future.
Yeah, I think that, again, obviously I have a lot of concerns with the contract. This is one of my concerns. I'm surprised that the other users of the network, they're not talking about it at all, but some issues around competition. We know that Baltimore Gas and Electric is in the business of providing gas and electric. But that doesn't preclude any entity from utilizing the conduit system in other ways that they aren't doing it today. Right now, the city is an unbiased kind of partner with everyone. You come to the city Department of Transportation, they're excellent employees, work with PG&E, work with Comcast, work with anybody. But it seems now we're starting to get murky with this agreement and potential capital improvement work potential capital improvement investment between the other entities if there was some area of competition. I know you can't speak to that. You probably have nothing really to say about it.
Mr. Council President, sorry, if I can answer that, I just want to reiterate, again, the city will own every inch of the conduit, just like it did 2 weeks ago, just like it'll do 2 weeks from now, a year from now. And so the answer to that question will be the same 2 weeks from now, 2 months from now, 2 years from now, as it always has been. Anyone else, the city has complete control over who has access to the conduit.
I guess that's not getting to my concern. My concern is if BG&E is in the primary position to decide what work gets done, they're not. You said no.
I'm sorry. I'll let you finish.
No, is that accurate?
I thought you were going to say are they a primary position to decide who has access, and I was going to say that's not the case.
This is not an access question. This is about competition question.
Yeah. So BG&E has discretion over how they want to spend their capital improvement money, subject to their collaboration with the city. But I'll let you finish your question.
Hang on, I want to address that, Mr. Deputy Solicitor. So, BGE and the city have always agreed, because BGE prior to this never had a right to proceed unilaterally. That's why they've always agreed. They were contractually obligated to agree. They didn't agree because they're nice people. You all seem very nice. But let's be clear on why you all have always agreed. The city and BGE have always agreed because they've been contractually obligated to. This contract changes that. So now it's not about a pattern of conduct. It's not. They have always agreed because they had to. This means they don't have to anymore. That's not to say they won't. BGE's been a great partner to the city. No question about that. I'll be the first one to say that. But they don't have to with this new contract, so let's be clear about that. And let's be clear about and I'm not saying the reason that they have always agreed is because they were contractually obligated to, but they had to agree, whether they wanted to or not. And that's a fact, an undisputed fact.
Mr. Chair, they still don't have the right to act unilaterally. There's still, we still have to approve, there's still inspections, and we still have the mandated monthly meetings. So there is no unilateral action. I do disagree with that.
Yeah, when you say have to approve, what do you mean approve?
Approve the work they do, sir.
Approve the work that they do. So again, I guess what we're getting at is they get to decide the work that they want to do. The city has to approve it, has to inspect it, have to maintain it, but they're deciding what work gets done, you know, whether it's Pratt Street or Light Street. They get to decide where they want to do the work, correct?
During a collaborative effort, during the monthly meetings, we would notify that. But everywhere that they are as part of the conduit system, they are every place of the conduit system.
Herein lies the problem of competition. We understand and know the work that they're in today, but for tomorrow, if I'm company ABC and my interest is, and I have limited interest because I'm not everywhere like BG&E, my interest is in one particular area, right? Just to make it real simple. BG&E can literally decide that they're not going to do work there, and they're only going to do it in another area that I'm not. And they're providing the same level of service. They're providing the same type of service. I think that that's the concern. Another concern is I'm company ABC. Now I have to share my capital improvement plans or costs or investment with BG&E, who could potentially be my competitor. The city, if this does not make any sense, please speak up. The city is sitting in a position, again, that's unbiased. Like, we don't care. We want everybody to provide great service to our citizens. That's not necessarily going to be the same interest of a private institution that has really full control over what they're deciding to do.
Mr. President,
I was going to say, BG.
If I may, we just don't interpret the contract the way that you do, the agreement the way that you do. And I know that I've said it before. I've called it 3 checks. I actually thought of a 4th one that I think is important for your line of questioning. So starting off with the coordination with the city, the monthly meetings on what projects we jointly agree should be pursued, right? That is a check on what work we do. Second, we need to receive all of the appropriate permits and meet the standards of the city to be able to do the work. That is a check. And at the end, that work must be accepted by the city. That is a check. I think another important one, when the question, when you talk about competition, someone said earlier rightly,
I'm sorry, say that again.
When you bring up competition, someone said earlier correctly that we are a monopoly. We do not have competition. For our service territory, there is no other electric provider. We are the only one. You may have thoughts about that. But what is really important, and it's stated in this agreement, and I'll look for the citation for you, is that the work we do must be for all of the conduit users. It is explicit in the contract. That's a fourth check. That goes to the question that you're asking about whether this agreement permits us to only make investments that serve BGE. That's explicitly prohibited in this contract.
I guess when I was talking about competition, I don't think anybody's in the business of setting up an electric company. The level that it would take to do that is extreme. I was talking about in reverse, like BG&E participating in distributed antenna systems, BG&E being interested in utilizing the conduit system for broadband, BG&E potentially going down the path of the middle mile to get closer to the community because they have access to kind of build out this network. That is the concern that I have moving forward. There's already been a significant push for the light poles. BG&E's recent past agreements with procuring the light poles, right? We know that this talk, we talk all the time and pat ourselves on the back that we want Baltimore to be a smart city. We want to move in that direction. The conduit system is going to serve as a critical infrastructure to do that. I think that's where folks are starting to get concerned of the administration not having the vision and looking forward and thinking about looking forward and potentially setting ourselves up in a way that it's kind of putting us in another pickle. Kind of like what we were talking about earlier associated with not proactively working out the agreements with some of the folks that are kind of stuck in their current agreement. That is my concern. And I know that you don't have the ability to speak for ultimately what PG&E would like to do as a corporation, and I'm not asking you to do so. What I am saying is that obviously from a city's perspective, we haven't thought that through with the contract the way it's written and the deal the way it's written.
So I'll do what you're advising me. I'll stay away from the main question about our corporate interests in the future. But speaking to this agreement, we think that it's pretty clear that the work that we're doing here, to borrow words from my friend from Comcast, is in the shoes of the city, right? We are working on the city's behalf under this agreement. Any work we do outside of that is a different set of work. Under the work that we do under this contract, it has to be to benefit all users, not in pursuit of some undefined goal that one might think up at a council hearing.
And I totally understand that, but we also understand that when we talk about conduit facilities, right, and everyone has access because they have an agreement with the city, that's doing work on behalf of everyone, correct? Because anybody could use it, correct?
Sure.
Is that what you're saying, on behalf of everybody? Anytime you do any capital improvement in a conduit system that I have access to, you're doing it on behalf of all of us, correct?
So long as we're doing it in coordination with the city and
so long as you're doing it in coordination with the city. But again, I'm ABC, I'm over here. Your capital plan is only focusing on a different quadrant of the network. That might not be beneficial to me directly.
It may not be, but the decision is being made by the city in concert with us. It's not to
the contract doesn't
disadvantage
say
ABC.
that the city is part of that decision. The contract says that you're going to meet with the city on a monthly basis, like you've been meeting with the city. The contract says that the city would have the same level of inspection and oversight that we currently do today. But the city knows nothing about your business model, nor Comcast's business model, nor Crown Castle's business model. And there is no business out there that's going to give up potential revenue opportunities just to kind of play nice. And again, this has nothing to do with BG&E. my concerns this entire time has absolutely nothing to do with BG&E. If I was BG&E and I was your attorney, I was inside BG&E, I would absolutely love this deal. As the president of City Council, I have to speak up on behalf of our citizens, not just today, but again, in the next generations. And I think that this deal is extremely flawed, has not been thought through, and lacks vision. I don't think that that's new. I've constantly communicated that, and that's where my concern is.
Understood, sir.
Council President, if I could add just a little bit for a moment. The one point is that we will still have revenues coming in. The condo division will still be doing certain aspects of maintenance and some capital improvements. My understanding as it is right now, the conduit users themselves don't specifically request projects in specific locations. Now, we, the division staff, may look at it and see where we have an area of high maintenance requests, things like that, and we might deem that we need to do more work in a particular area. And so we will still be looking to determine what locations, what projects we will be doing under this new arrangement. Additionally, if there is, again, as I said, under today's standards, there are different conduit users who are adding to the system, whatever the need might be. If they want to provide some new services, whatever it is, they are potentially coming into the network as it stands today, getting permits through DOT and going out and doing those work to add to the conduit system, and then therefore benefiting. So there's still multiple opportunities and ways that ABC Utility or whoever it is can get their needs met. We have various service requests that we get coming in from the different users. That'll also inform where we're looking at doing work. And again, a lot of times when we're looking at projects and things throughout the city, we might try to do some conduit work as a part of that. So there's going to be so many different areas of us trying to consider the needs of all the users. And additionally, when we receive, say when we're talking about the proposed projects that BGE would be pursuing, we have the ability to look into our asset management system and try to determine what other users are in a particular area. So, I understand your concern, and if it happens to be that out of the 76% occupancy areas that they are, we found where they're trying to do work in one area where no one else is there. I think it's really slim, relatively speaking, that there's going to be locations where a high number of locations where they're not doing work that's going to directly benefit the other users in some capacity.
Yeah, again, I totally agree that any work that's done on the conduit system for everyone who has access to the conduit system is work that's being done on behalf of everyone. I guess what I fundamentally have concerns about, again, when we talk about smart cities, when we talk about distributed antenna systems, when we talk about the wave of where we should be as a city in 20 years, I think that this deal sets us not in the primary position to benefit real competition in an equitable way. I could be wrong. We could look back in 20. The thing about this stuff, guys, is history doesn't lie, right? We can kind of sit here and we can act that this is kind of our motivation. We can act that these things aren't of concern. We can act that the vagueness and the ambiguity of this contract was not intentional. But the reality is, and what we know in America, being a very capitalistic society, is history doesn't lie. And these hearings and these investigations and the subpoenas and the questions that this council has asked, I think everyone can agree, has been done in the spirit of just trying to get the best deal for our citizens, not today, but also in the future. And with my professional background, I have some severe concerns about the position that we're putting our city in as it relates to growing into being a smart city, and kind of pushing us towards the support of private institutions that would be able to benefit greatly from it. So with that, I'm going to close out. I don't have any additional questions, Mr. Chair. If he has no additional questions, I'll just say I'd like to thank everyone for sitting down and supporting the council and going through this effort. I think there's been a lot of time and attention that's been placed over the past couple of weeks, obviously because this was thrown at us like, a bag of bricks. But we're here. Again, I think the spirit of this council has been to just be that level of oversight for our constituents, ensuring that we provide real transparency and true transparency on this really, really important issue that I think, again, is not just impacting us today, but it's kind of potentially like the Friendship Airport discussion of 1972. With that, Mr. Chair.
Thank you, Mr. President. I want to thank everyone, city agency folks and our utility providers, for being here with us for 4 hours. We're going to recess in a moment. We received a large package of information, which at face value appears to be very responsive. In terms of document titles, I haven't gotten to the content yet. One of the PDFs that you sent was 490 pages, and I haven't learned how to speed read yet. We're going to review that information. We'd like to come back and talk about that information that you provided us. There were a number of document requests that were made this evening. I think we're going to work with our general counsel and hopefully get a request over to you all in writing tomorrow as expeditiously as possible so we can move this along. We're going to go into recess, and we'll be back on Tuesday, February 28th at 5 p.m. Tuesday, February 28th at 5 p.m. Thank you all. We're now in recess.